detaining officers, other detention centers, the police should make sure that the child has a lawyer that should represent him or her at that level. And then from that level, if you have a lawyer representing the child, it becomes easier to go ahead and process the child either into prosecution, as the case may be, or sometimes you get the cases sorted out at the level of the police station with the intervention of social welfare agencies and other things. So for us in Legal Aid Council, we are the primary vehicle for access to justice for children and, in fact, for everyone in the society. And especially those of us, and we are much aware that the majority of these children that we are talking about are children of the poor and the indigent in the society. These are people who cannot afford to have legal representation of their own. So this is where Legal Aid Council has come in to play a very important role. And we are playing this role alongside the Nigerian Bar Association. And like I've said, it is very interesting and it is very something to be commendable that we have already started what we are doing with UNICEF in order to have this data that we so much crave for, so that we can be able to find solutions to the numerous problems that are associated with children. There are challenges. I hope this session we discuss the challenges, but we intend to continue with our collaboration so that we can solve the problem as much as we can be able to do. Thank you very much.
Thank you very much, the Director General, Legal Aid Council. You have highlighted the importance of strengthening the police duty solicitor scheme as a framework for addressing issues of pro bono legal services for children in contact or in conflict with the law. Now, we've heard from members of the panel, but there are a few strategic interveners that I would like to request to intervene. We've looked at the institutions here represented, but we also know that under the Nigerian Constitution, both at the federal and state level, the Attorney General have the power to initiate, take over, and discontinue prosecution. We have with us here the Honorable Attorney General and Commissioner for Justice, Ebonyi State, who is also the chair of the body of Attorneys General. Can we have a roving mic, please? Let's hear from your experience as an Attorney General. What role do you think Attorney Generals across the Federation can play in ensuring that children do not get charged for an offense without first considering diversionary measures in line with the extant provisions of the law? Can we have a microphone go to the Honorable Attorney General, please? Your time starts now.
Thank you. For paucity of time, let me align myself on the plank of protocols that have been established. I am happy that I'm an intervener in today's discourse. The Act has laid the legal architecture for diversion. Now, the Section 1 of the Act provides that the best interest of the child shall be the primary consideration in every diversion in suitable, non-serious offenses. But the problem we have is that while the Act provides for statutory rights, converting and translating these statutory rights into lived reality is a problem. But until we have and intentionally care for the governing principle, that will help in translating these statutory rights into lived reality, we won't be able to achieve diversion. Now, I am also glad, and I pledge as an intervener on behalf of the body of states attorneys general, that we are going to carefully implement Section 209 that provides for case diversion measures. Prosecution should be the last resort. Case diversion measures in suitable non-serious offenses. The section is very clear. It expressly provides for 5 case diversion measures. The first is supervision. The second is guidance. The third is compensation. The fourth is reintegration. And the fifth is reconciliation. How do we do this as honorable attorneys general of our various states? Very simple. Number 1 is by using our inherent prosecutorial discretion in establishing prosecutorial policy and guideline on diversion. So if we have that policy on diversion, the children prosecutors and the children prosecutors from the Ministry of Justice and the specialized child police units will be able to have and come together and then work out that policy that will guide everybody that is prosecuting a child in conflict with the law. So we make bold to recommend that each Attorney General should have this policy, prosecutorial policy on diversion. You can name it anything, but let it just be prosecutorial diversion guideline and policy. It will expressly state that. Secondly, sir, I also recommend institutional coordination. The Office of the Attorney General should have strategic relationship and link with these specialized police units. Unfortunately, most Ministry of Justice do not have specialized children prosecutor units. My commitment is that charity begins at home. Even me talking, I do not have. But leaving this place is an assurance to UNICEF that by next week I'm going to be creating that child prosecution unit. And then we will now interface with a police specialized unit for prosecuting children. With that, we'll be able to have full implementation of diversion. Thirdly, is monitoring and accountability. I was shocked to hear the number of children that are incarcerated in Nigeria. We need to have data. If police have data, the Correctional Service have data, Ministry of Justice have data, we'll be able to resolve this issue that is looking at us. For MBA, what we just need is to have capacity, professional capacity with MBA to show that they have the capacity for legal representation by Ministry of Justice in collaboration with Ministry of Women Affairs. Because my own state domesticated the Child Rights Act and made the Ministry of Women Affairs to be in charge of children in conflict with the law, while the Office of the Attorney General supervises what they do. So if we have a memorandum of understanding between the Ministry of Justice, the Ministry of Women Affairs, and MBA, we'll be able to provide the effective legal representation required. So if we have that MOU, and we have this prosecutorial case diversion measures policy and guideline, and then the monitoring and the accountability in place, I am sure that by next year, it will marvel you of the expected outcome that you will see. Thank you.
Thank you very much, the Honorable Attorney General, Ebonyi State, Dr. Ben Uruchi-Odoh. I think you've kicked off the commitment aspect of this event, because it's not just sitting here and discussing this. We must each make our own commitments. You can imagine if every lawyer in this hall decides to take up one pro bono case in respect of a child who is in conflict with the law. You can imagine what that is going to translate to. So thank you for that commitment, and I hope that you will share this with your fellow attorneys general so that they will be able to adopt and implement what you've committed to in their respective states, and that will make the child-friendly justice we are talking of accessible. At this point, let me also invite our indefatigable sister, Professor Joy Ezilo. I'm aware you were the first person to introduce teaching of women, children, and law in any Nigerian university in this country, at the University of Nigeria. You also hold about 7 traditional titles or thereabouts. You are a learned senior advocate, and you are also a member of the body of benchers. So, Prof, you are a life bencher, actually. So, Prof, you led the technical review of the 2007 National Child Policy, which is ongoing at the moment. Listening to the panelists and what we've done today, what do you think we need to do to address this? And before you answer that question, let me formally recognize the arrival of the Honorable Minister for Women Affairs and Social Development of Nigeria, Iman Aisha Suleiman, who has just joined us from Abuja. Honorable Minister, you're very much welcome. You're welcome. So back to you, Professor Joy.
Thank you so much, Moderator, the Honorable Minister, distinguished ladies and gentlemen. Really, when we did the diagnostic review of the 2007 National Child Policy, it's very clear that our work is far from being done. One is sometimes the policy disconnect, and what has been also mentioned by some panelists here, between the actual provision and then also implementation, because it wasn't just the gaps that we also found, but also about even limited implementation of even some forward-looking suggestions in the policy. So to the issues that we have before us in terms of the justice system and for children who are in conflict with the law, we see, we in the diagnostic review, try to use green, amber, red to see, to just color where we think progress has been made and also where those gaps are in the law. Then you will find that in as much as some can say the standard is no longer the problem. For me, at international and regional level, the standard is not the problem. At also domestic or national level for us, the standard is still the problem. And we will get it right by also imputing all of those things we've identified. The procedural safeguards that are absent, especially before, during trial, and then also the fact that we have to understand what is the aim and objective of maybe, say, juvenile justice system or justice system for children. The aim is also to integrate their well-being, to have regard to their dignity, to understand that their capacity is evolving, and that the immaturity, the state of, they are not yet matured, and to treat them in accordance with that, and also proportional to the offense. The age, major gap also, the age of criminal responsibility, I think is too low in our system. A place where you say a child who is under 7 years is criminally irresponsible, dully incapable. And if he's 7 years and above, then he's criminally responsible. How is it possible? Especially given what we know. So every state needs to actually address that and raise and determine their age of criminal responsibility, and also raise that up in accordance with the Beijing rules, with the Raya principles, with the UN Convention on the Rights of the Child, with the African Charter on the Rights and Welfare of the Child, that Nigeria has ratified and has state responsibility to implement. The minimum age of criminal responsibility is overdue. Diversion from former judicial proceedings. And please, let us understand this diversion. When we talk of diversion, it doesn't mean no accountability. Because at times we mistake it that no accountability. No. But you treat them in accordance with their age and proportional to knowing that they are under 18. And how does the law define a child? A child is a person under 18 years of age, unless under the law applicable to the child, majority is attained earlier. So you treat them in accordance. Let me tell you one case. I have had a lot of cases. I've done pro bono cases. Like you rightly said, I started teaching children, women, and the law, introduced it at the University of Nigeria Faculty of Law in 1997. And then since then, to date, it's been taught. It's become part of National University Commission curriculum. Some universities have picked up, some have not. But I tell you, because we've started it, many lawyers are better for it today. When I meet my students all over, working all over the place, they are very happy that they had the opportunity to study even things like juvenile justice system, to study things about child protection, to understand how the justice ecosystem doesn't work for children. Yet we say we value children. Yes, we do. But we don't take their best interest as the primary or the primordial, paramount consideration. And the law requires us that in all proceedings, whether undertaken by judicial or non-judicial bodies, the best interest of the child shall be a primary consideration. Time to act is now. And I agree with the Honorable Attorney General. Let us make commitment. And that commitment, the symbol of that is our Honorable Minister. Her presence here now shows a person who is determined to rewrite the history and the narrative for children of Nigeria. Madam Honorable Minister, thank you so much for what you're doing for children of Nigeria, for what you're doing for women of Nigeria, and how that commitment is why you're here. We know what it is now in the politics. Thank you so much, and thank you for being here. And thank you, UNICEF.
Thank you very much, Prof. I know that if you are allowed, you will go on and on and on. But thank you for that strategic intervention. And of course, we all know what the Honorable Minister has been doing in terms of promoting the rights and welfare of children and families, indeed, in this country. Let me also then invite a core practitioner, someone who is standing astride law and social services. She is the Executive Director of PRAWA, and she was the technical lead in the assessment of the situation of children and young adults who are deprived of their liberty. Dr. Juagomo, all we have been discussing has looked at gaps and failures in this system. Can you help us identify where do these gaps exist? How do we fail our children who are in contact or in conflict with the law? And what do we need to do to address this challenge? Very briefly.
Thank you very much, Honorable Moderator. Thank you. Our protocol is duly observed, but I recognize both the Minister, the panelists, Leonard Six, and everyone here. Very quickly, I think in terms of identifying the gap, let me first say, because you mentioned about the statistics, and yes, I led the research that brought up those statistics. The 133,000 is important to know that those 133,000 are not only found in custodial facilities. At the moment, there are about 19 institutions in this country that detain people, including the police stations, including NDLEA, and many others. Yes, we have 133,000, but I dare say that that is not even the whole picture. There were facilities that we did not have opportunity to have access to, and I think one of the gaps we must make sure we close is that all places of detention in this country must be known and accessible to independent observers and monitors, because that is part of the recommendation of the United Nations to Nigeria during the last Universal Periodic Review of this country. Number 2, it is important to see a gap in terms of the conceptualization of the need to address this problem, and to see that we are all part of that solution. And what am I saying here is the problem of awareness. So when we look at the comment that was made by the representatives of the Controller General of Corrections, who told us the real truth in this country, that we have laws, but we lack commitment, lack capacity, lack ability to put resources to implement the recommendations and the provisions of the law. Let me use as clear examples to show you that gap. He had mentioned to you that Section 13 of the Nigerian Correctional Service Act of 2019 empowers the Correctional Service to say no to admitting any person who is underage. That same provision enables you to check the age of the person before you get the person in. But as we speak now, there are only 3 postal institutions in the country. One in Ilorin, Abeokuta, and one in Kaduna. And of these 3, none is a female facility. Not to talk of the fact that the same law, both Section 34 and 35 of the law, speaks about the need to have in every state of the Federation a facility for young offenders, as well as a facility for women. Number 3, during the research that was supported by UNICEF and partnered with all the government agencies, we found that there are about only 29 states have remand homes. The question therefore is, if your state does not have a remand home, and your state does not have any postal institution or young offenders institution close to it, where are the young persons kept? Where do we keep them? And therefore, this is why I want to now make a very fundamental additional recommendation. And that recommendation is, yes, you have spoken about the need to have a multi-sectoral approach in terms of ensuring that different professions are brought back. But I dare say we need the whole of government and the whole of society's approach in dealing with this problem. What do I mean? I mean that the government, the whole of government, not just the Ministry of Women Affairs, Ministry involved of Youth, Ministry involved in education, all of us must understand that dealing with the children means we're investing in our future. It is not only the government. The whole of society's approach requires that both the government but also the private sector. I do know that today we have the National Legal Aid Strategy of Nigeria, 2026 to 2036. But that strategy must be operationalized, must be owned by the bar and by everyone. Final comment. At the moment, we have paralegals being taught in about, at least we have about 16 universities, plus the NUC keen into this. But let's all work together and demand accountability. When it's not working, make it change. Ensure that both in your home, in your community, in your families, you do something about children. Let all of us do this, and I think we'll be better. Thank you, and God bless this meeting, and God bless Federal Republic of Nigeria.
Thank you very much, Dr. Uju Agomo. The passion is unmistakable. And the emotions are also there for all to see. And if we borrow a bit of that from you, we can all contribute our own quota towards ensuring that we have justice for every child in Nigeria. Let me invite the last strategic intervener before we take a few questions or comments from the audience. Mr. James Ibo is the head of Basic Rights Council Initiative based in Cross River State. And he's had several cases that he has intervened in, even as chairperson of the Child Protection Network of Cross River State, the immediate past one. Mr. James, can you just let us know, in the course of your interventions in promoting access to legal services for children in conflict with the law. What has been your greatest challenge or the great key challenges that you have faced in trying to provide these services for those children in need? Very briefly, very briefly.
Thank you very much. I think the first is legal gaps, like the Child Rights Act. I'm happy that Mr. Polycarp is the one heading, and I'm not afraid he's going to do a good job. I think one of the things we have to include in the Child Rights Act is mandatory reporting, and also providing timelines and punishment for inactions. Because most times when institutions or heads of institutions fail to take actions, nothing happens. So by the time we recruit more lawyers to provide pro bono services, they will have basis to go to court that the court should award damages or punishment to institutions or persons who fail to act or who acted wrongly. Then to the police. The police has enormous role to play, but with a lot of officers, with poor training, and funding is also a problem. The police is poorly funded, and we expect them to do magic. Most times they criminalize even those who report cases, or even the children who are survivors of offenses, because they need to raise money so they can be seen to be doing their work. Then for the correctional service, yes, most of these remand warrants carry ages. When your assessment shows that he's a child, what actions do you take? Now, for Ministry of Women Affairs, the law mandates you to coordinate activities with the police, with the correctional service, and even the legal aid council. Oftentimes, the ministry is not funded, or they don't know what to do. So how do we create a hub or a center where these cases are quickly analyzed so that intervention will be very quick? We can talk to tomorrow. We were here last year. We talked about these issues. Funding is material. Budgeting, budget releases is where we fail. Then we can talk about training. Most times we allow civil society organizations or international donor organizations to do the work. We are talking about social welfare officers. We have a lot of gap. No social welfare. We are graduating social workers every day from our universities. Many of them are not employed. So we have those who do not have the capacity to do this intervention, doing this intervention. Then the family court has to be expanded, and the provisions on the jurisdiction of the family court has to be properly interpreted. How does it affect those who are survivors of offenses or those who are children in conflict with the law? We have to also talk about the assessors and social inquiry report. Because most times, if you go to this court, nobody talks about social inquiry report. We recently had a case in Obubra in Cross River State, and the police attempted to detain the child in conflict with the law. And all my explanation could only be resolved when money exchanged hands. It's too poor. And most times, I think we also have to look at the community-based rehabilitation process, which is very traditional. How do we marry it with our modern-day policing? Thank you.
Thank you very much for those practical steps. I'd just like to have an opportunity for the audience to participate. Maybe 2-3 questions, comments, or interventions, and then we'll be able to deal with it. The man in the red hat there. Straight to the point, please. We are slightly behind schedule.
Thank you, sir. My name is Adenchin Makandik Elijah Haley from Abuja branch. My concern is for abandoned children, otherwise called street children. We have many children on the streets who wake up and go to bed without any parenting. And with that type of situation in our country, then we can be sure that crime will always be on the increase. How can we use the law to take care of street children or abandoned children? How can we create safe house for those children to have 3 square meals, to have formal education, I think these are some of the things that the law should look into. Thank you very much.
Thank you very much for that one. Let's have a lady. The lady, yes.
Thank you, all the panelists and the contributors. Amijoma Mike Ajanwachuku. My Honorable Attorney General is here, Ebonyi State Ministry of Justice. My question goes directly to the police, the IGP. Yes, you said that police officers are being trained. I stand to say that police officers have been trained and still are in training, yet no impact has been felt. Yes, sir. Then my question is there anything the IGP can do where we are expecting results on child-friendly system and yet we get nothing? Is there anything the IGP will do so that we can now achieve our target results? Thank you so much.
Thank you very much. One question from this side.
Good morning, gentlemen of the bar, the panelists. My name is Obaje Fanye. I'm from Nigerian Bar Association, Owerri branch, the most peaceful branch in Nigeria. My question is this: what are the remedies? What are the judicial remedies for these children? Because without remedies, we continue to move left, right, center at the same time. Then, I have a serious question to the Inspector General of Police, who is here present. Our colleagues who went to court for not being properly remunerated and promoted, what have you done in your capacity? Those lawyers working in Nigerian police force who went to court as a result of not being promoted, no proper placement, and being under-remunerated, what have you done over the court judgment that was secured on their behalf? You have a reasonable question to answer. Thank you, sir.
Thank you very much. As moderator, I will overrule the later part of your intervention because it's outside of the remit of why we are seated here today. So that is overruled. In terms of the first intervention, part of the partnership between UNICEF and Nigerian Bar Association for the provision of pro bono legal services has capacity building for lawyers as a key aspect of it. So that will also address the question you raised about remedies that are available. I think I've even saved you from answering the question that has been posed to you. At this point, no, we are running out of time. We will not be able to, because we still have the ministerial session as part of this session that is going. If you look at the concept notes that you have, and you also look at the flyers that you have, there are 3 QR codes. One contains the concept note. The second one, if you scan it, it gives you an opportunity to input your details, name, gender, branch, location, and all the lawyers who are interested, able and willing to provide pro bono services and also to be trained, you can register and submit to your respective branches. Fill the form and submit it, and it will pass across to the national headquarters so that we have a database of lawyers who are ready and willing to provide pro bono services. The last QR code contains all relevant international, regional, and national documents relating to rights of children and issues relating to justice to children. So it's available. You can look at it. But most importantly, there will be accredited courses on justice for children, which will be hosted by the Institute of Continuing Legal Advision of the Nigerian Bar Association, that lawyers can take advantage of to improve their knowledge on issues relating to justice for children. And then finally, part of the framework of the partnership will require that at each state there will be facilitated by MBA a convening that brings together all the justice institutions in the states, the corrections, the police, and all the other institutions, including the Legal Aid Council, and of course the relevant MBA bodies, so that they can coordinate, determine what challenges face them in their respective states, and conduct advocacy both to the Chief Judge, the Attorney General, the Commissioner of Police, so that at the end of the day, that coordination that we have talked about will be realized and will be used to promote access to justice for children in contact or in conflict with the law. In conclusion, I want to remind us that we were all children before we became adults. I want to state that if many of us had taken a wrong turn and we are not properly guided, we may not be where we are today. It is on that note that I want to express my profound thanks to members of the panel, the Director General of the Legal Aid Council of Nigeria, Aliu Bagudu Abubakar, also recognizing Dr. Idris Yahya Atta, the Director, Child Development of the FCT Women Affairs Secretariat, Likitila Cyrus, who is representing the Controller General of Corrections, CSP Lasisi Babatunde, here representing the Inspector General of Police, and of course, the last but by no means the least is our erudite scholar, Polycarp Chibueze Okorie, who is the technical lead for drafting and member of the Child Rights Act Review Committee. Ladies and gentlemen, distinguished participants and my learned friend, on this note, we draw a curtain on this panel section and will make way for the ministerial session that will be taking place immediately after. And may I invite at this point members of the panel for their photograph, and thereafter presenters of souvenirs, and Mona Aika, who is the Child Protection Manager for UNICEF Nigeria Country Office, will take over proceedings as moderator of the ministerial session. And once again, we welcome our indefatigable Honorable Minister of Women Affairs and Social Development, Aisha Iman Suleiman, who is here with us at the moment. Suleiman Ibrahim, sorry. Thank you very much for making our time to come. Mona, the floor is yours. And can you put your hands together for us as we take a group picture?
Thank you very much, Godwin, for moderating that session. Another round of applause to these very esteemed panelists that have just finished a very important discussion pertaining to the rights of children and really moving paper to practice, ensuring that the laws are actually implemented and suggesting very critical areas that we need to focus on. my lords, learned senior advocates of Nigeria, Mr. President of the Nigeria Bar Association, distinguished members of the bench and bar, government colleagues, international delegates here present, and all esteemed colleagues from UNICEF. Good morning. I want to thank you for your patience. I want to thank you for the attention that you actually portrayed during this first session. We had to adjust our agenda so that we're able to ensure that we make the most of this high level, the senior level, ministerial level discussion. So my name is Mona Aika, and I'm the Child Protection Manager for UNICEF Nigeria. And I have the honor of moderating this next session, which is really the ministerial conversation. This conversation builds directly on our engagement at the 2025 NBA Annual Conference. May I request panelists to take your seats? May I request the panelists to take your seats, please, so that we can have an audience? Thank you very much. This conversation, ladies and gentlemen, builds directly on our engagement at the 2025 NBA Annual General Conference, where for the first time, UNICEF convened 2 dedicated sessions on justice for children, looking specifically at how best we can intervene early. In that session, distinguished ladies and gentlemen, we had a lot of theories on the importance of rights, importance of child-friendly justice systems. And this year, we're focusing on what have we done, what implementation is taking place to ensure that children receive their rights. And from this panel, you have seen different sectors coming in, drawing from the examples that they're having from their respective offices and states, and outlining what needs to be done. There is still a lot that is still weighing on us, but nevertheless, we have that enabling environment. So without further ado, I would like to invite the distinguished panelists to join me on the stage, starting with the Honorable Minister of the Federal Ministry of Women Affairs and Social Development, Hajia Iman Suleiman Ibrahim, to join us, and Prince Latif Fagbemi, SAN, Attorney General and Minister of Justice, to join us here, ably represented by Mrs. Letitia Ayola Daniels. Please join us on the stage. To kickstart this conversation, I know many of us are very excited, and we're very thankful to have the Honorable Minister of Women Affairs and Social Development with us. So we're very grateful that you're here, and we're actually quite excited for you to come in as the leader of matters concerning children, women, and families, to also give us your thoughts and also experiences. But before I do that, Honorable Minister, allow me to start to set the scene before you come in, so that you can come in and really give us your message, and also, most importantly, your input to some of the discussions that we've had. So I would like now to welcome the UNICEF Chief of Child Protection, Natalie McCauley, to give us an opening and set the scene for this discussion before we proceed further. Following Natalie, we'll hear also from the President of the NBA Association, so that we can also get a few words, and then we'll have from the Ministry of Justice, and then the Minister will come in and deliver her remarks and her experience. Over to you, Natalie.
Thank you. Thank you, Mona. My lords, learned senior advocates of Nigeria, Mr. President, distinguished leaders of the Nigerian Bar Association, honourable ministers, particularly our honourable minister and friend, thank you so much for taking the time to come with us. Distinguished members of the bench and bar, international delegates and leaders, development partners, civil society colleagues, ladies and gentlemen, I just want to make sure all protocols are duly observed. Good morning. It's really a privilege to be here today and to see so many of you here at this conference. And it's a privilege to be in partnership with the Nigerian Bar Association. Particularly, it's important that we have this discussion on justice for children. And the theme of the conference is Beyond Limits, which is very poignant for what we're talking about today, because Nigeria is a country of children. Nearly half of your population is children. And because of that, it's really serious that we talk about justice for children. We must indeed go beyond the limits to make sure that we go beyond response to prevention, beyond laws on paper, which we have discussed already this morning, that change lives instead, beyond the courtroom to the police stations, the community, and the places where children first encounter the justice system. Beyond detention as a default response towards diversion, rehabilitation, and reintegration. And beyond institutions working in isolation towards a justice system in which lawyers, judges, police officers, prosecutors, social workers, correctional authorities, and communities work together around one overriding principle, which is the best interest of every child. Nigeria has an important legal foundation for this to work, and some of that has already been discussed this morning. But the application and implementation is where we have gaps. We need to progress this. We have the Constitution of the Federal Republic of Nigeria, which guarantees fundamental due process, protections, and access to legal representation. The Child Rights Act establishes that the best interests of the child must be a primary consideration and provides a distinct child justice framework. The Legal Aid Act 2011, the Administration of Criminal Justice Act 2015, the Violence Against Person Prohibition Act 2015, the Nigerian Correctional Service Act 2019, and the Police Act 2020, and corresponding state laws providing further foundation for protection, fair process, and access to justice. Nigeria stands ready, and we have an additional platform, the Nigeria Justice Policy from 2024 to 2028, which gives us that additional foundation to strengthen an effective and accessible justice system. While the ongoing review of the Child Rights Act provides an important opportunity to ensure that legal frameworks respond to, contemporary realities and strengthens implementation. So the question before us this morning is not simply, do we have the laws? I think we've established that we have the... Is it open? Sorry, spoken much about them this morning, but children with disabilities, a child living in poverty, a displaced child, or a child in a diversion or court proceedings, protection, rehabilitation, and reintegration. Strengthening the skills of lawyers in child-sensitive practice, connect MBA branches more systematically with legal aid counsel, police, courts, correctional institutions, and social welfare services, and ensure that a child's access to a lawyer does not depend on whether somebody happens to know somebody. Because a child's right to
adults. I listened to Professor Juagomo and others who spoke. And they gave us statistics.
From that intervention, I would now like to welcome a representative from the Ministry of Justice, the Federal Ministry of Justice, Mrs. Letitia, who is here representing Prince Lateef Fagbemi, Attorney General of the Federation and Minister of Justice.
Thank you, Mona. Honorable Minister, Women Affairs and Social Development, the NBA President, highly esteemed Leonard Silk, my lords, distinguished colleagues at the bar, the Chief Child Protection, UNICEF Nigeria, ladies and gentlemen, good morning. I have the distinct honor to represent the Honorable Attorney General of the Federation and Minister of Justice, Lateef O. Fagbemi SAN, who is unable to attend due to pressing official engagements. I am honored to participate in this important session on justice for children and to join the Nigerian Bar Association and UNICEF in presenting what I consider one of the most significant child justice initiatives currently underway in Nigeria, the NBA UNICEF Pro Bono Legal Services Partnership for Children. Today, we gather not simply to discuss children and the law, we gather to confront a fundamental question of justice. Can we truly claim to uphold the rule of law when a child enters the justice system without protection, without representation, and without hope? For far too many children in Nigeria, the answer remains uncomfortable. I lend my voice to the matter that goes to the very heart of justice, the protection of the children, the protection of the child and his or her rights. For every child, there should be justice. Ladies and gentlemen, a child who comes into contact with the law, whether as a victim, witness, or alleged offender, does not need our sympathy alone. The child needs a system that 35 states and the FCT, but what we need is implementation, and we need to move beyond limits as well. The Federal Ministry of Justice is firmly committed to transforming Nigeria's child justice system into one that is rights-based, child-sensitive, restorative, and aligned with international standards. The Ministry of Justice ensured that for the first time, the National Policy on Justice 2015 recognizes justice for children as a distinct pillar. It commits us to diversion, restorative justice, child-friendly courts, and ending the unnecessary detention of children or situations where juvenile offenders are in the adult custodial centers. Next, we have the ongoing review and amendment of the Child Rights Act 2003, which was inaugurated by the Honorable Attorney General of the Federation. The committee was inaugurated, supported by UNICEF and International IDEA. This review provides a critical opportunity to strengthen the legal foundation for child-friendly justice, access to legal representation, diversion, and alternatives to detention, effective implementation of children's rights. In accordance with this session's theme, Beyond Limits is not whether rights exist in law or that there are adequate legal frameworks to governize such rights, but the real test is whether a child can effectively enjoy the rights when they are most meaningfully needed. For children, justice delayed is justice denied with very serious consequences, especially in cases of sexual and gender-based violence, where victims and their parents don't only carry the stigma of sexual abuse, but also sometimes carry cost of getting access to justice. That is why our approach is anchored on early justice for children. Early justice for children means acting at the very first point of contact, identify the child, act in their best interest, ensure the child understands, notify parents or guidance, provide immediate legal aid, assess welfare needs, avoid unnecessary arrest and detention, consider diversion, refer to social services, and begin rehabilitation early. To translate law into practice, the Federal Ministry of Justice, in collaboration with UNICEF, has midwifed and launched practical tools like the prosecution guidelines for children in conflict and contact with the law and child victims 2024. The prosecution guidelines for handling cases for the FCTI Court and the Restorative Justice Training Manual 2026, and we did carry out some trainings on that as well. Fourth, through broader justice sector reform efforts, we are strengthening coordination among prosecutors, courts, police, correctional services, legal aid institutions, and social welfare systems, because justice for children cannot be delivered by any institution acting alone. specifically through the Federal Ministry of Justice, SGBV unit, with collaboration with ESN, and no case is lost. While government has an important the protection of children's rights in the justice system cannot be achieved by government alone. This is why the NBA, UNICEF pro bono legal services critical stage, we need a very robust national framework for pro bono legal services for children, one that ensures availability in every community, sensitization and advocacy by lawyers, faith-based mobilization, offer pro bono hours in your place of worship. This is when law can truly be a medium of social engineering. Let pro bono services for children not be charity. Let it be professional duty, because access to justice for a poor child is the truest test of the vast relevance to the Nigerian people. Child-friendly justice cannot be delivered in silos, like I earlier mentioned. It requires the bar, the bench, police, legal aid, council, social welfare, corrections, and communities working together. Distinguished colleagues, the foundation exists. Our task now is implementation. Let us close the gaps. Let us strengthen referral pathways, ensure no child is left behind because of lack of access to justice or because his or her parents cannot pay a lawyer's fee. I therefore commend the Nigerian Bar Association for demonstrating leadership on this important issue, and UNICEF for its long-standing commitment to strengthening child protection systems and advancing justice for children in Nigeria. Together, this partnership sends a powerful message that no child should be denied justice simply because they cannot afford legal representation. I urge the NBA to take the lead in institutionalizing pro bono service for children. The Ministry of Justice stands ready to partner with you on policy, guidelines, and recognition for firms and lawyers who answer to this call. I also want to appreciate the Minister of Women Affairs for making it here today, because we need her more than ever. You agree with me that a nation that fails its children fails its future. Thank you very much, and God bless you all. Thank you.
Thank you very much, Madam Letitia, for sharing the Ministry of Justice perspectives. Before we move to our final speaker, distinguished ladies and gentlemen, I want to emphasize one point. All that we've heard about justice for children, it just doesn't end in the police station, in the courtroom, a lawyer representing a child. We must be able to connect justice with the social welfare system. Justice and protection. So this is a very important component which many times is missed. And that's why today I have the honor of inviting the Honorable Minister of Women Affairs and Social Development, Hajia Iman Suleiman Ibrahim, to join us and also to share her perspective. Thank you.
I'm honored to be with all of you, and I join you here with every sense of responsibility. We gather here, to forge strong, a strong front in addressing issues for 42% of our population that are under the age of 14. Averagely, 9 million babies are being born annually in Nigeria. No wonder we have dedicated one day to the issues of justice for the Nigerian child. And we're aware that no single entity can do it alone. So we must continue to work together as a team to emplace the strongest form of response for the Nigerian child. So on behalf of the women, the children in which are on the front burner today, the families, and the vulnerable population that we serve, I would like to extend my appreciation, my commendation to the NBA, the UNICEF, and other critical stakeholders that are here today. May I start by recognizing the president of the Nigerian Bar Association, the outgoing president, my brother, Mazi. I recognize you. May I also recognize the Attorney General of the Federation, Minister of Justice, who is ably represented by my sister Leticia, who is also the Secretariat. May I recognize all our learned colleagues. I would like to recognize the team UNICEF, and thank you for all you do in ensuring that we remain accountable to children welfare and well-being in Nigeria. Distinguished ladies and gentlemen, I'm truly excited to stand before this assembly. May I start by thanking the chairman of the Conference Planning Committee, Abdul Mohammed San, and his committee. I also want to thank the UNICEF Nigeria for the partnership that made this session possible. And on behalf of the Nigerian women, the children, the families, the vulnerable population, I congratulate this association on the election of Mrs. Oyi Kosola Badejo Okunsanya-San as the president, the next president, the very first female president, first elected president after 66 years of the Nigerian Bar Association. I would like to also salute the distinguished leadership of the outgoing president because it's not incidental to my subject. Her Lordship, Justice Kudirat Kekereekun, sits as the Chief Justice of Nigeria today. Her Lordship, Justice Monica Dogban Mensem, presides over our Court of Appeal. Mrs. Beatrice Jedi Abba, OON, today is the Solicitor General of the Federation. Dr. Olubemisola Odusate is the very first female DG of the Nigerian Law School. And the bar itself now is being led by a woman. This is a living expression of women o'clock in the Federal Republic of Nigeria. You know, that's how it starts. We're seeing women presidents across sector, and very soon it will happen. Thank you. Thank you very much. Justice in Nigeria has become more compassionate, more inclusive, and more effective. And we must take advantage of this season to get this work done. Distinguished members of the bar, allow me to briefly say something about your profession. Without the lawyer, authority hardens into tyranny, and power simply replaces justice. It is the lawyer who turns a constitutional guarantee into a living protection for a vulnerable child. Nothing I say today diminishes that. Everything I say going forward depends on it. I do not come before you as a lawyer, even though I was married to one and my son just graduated as a lawyer. Thank you. And I will not presume to instruct this room on the law. I come as the minister responsible for the Nigerian child at the moment the state touches the child. And I come having sat at 4 points along the very chain of this session and why it's being convened to fix. As the DG of the National Agency of the Prohibition of Trafficking in Persons, I saw a child at the point of rescue. Through the alternate school program I championed at the Ministry of Education as the SA to the Minister of State on Education, I saw the child already out of school. At the National Commission for Refugee Migrants and Internally Displaced Persons, I saw the child displaced, undocumented, and therefore invisible. And as the Minister for State for Police Affairs, I saw the child in the charge room before any lawyer had been called. And now, as the Minister for Women Affairs and Social Development, I sit on the other side of the chain entirely. Not at the point of rescue, but at the point where a child should never have needed to be rescued. Having stood at each of those points, I can tell this conference where the chain breaks. It is almost never where we assume. It does not break in the courtroom. By the time a child reaches the courtroom in Nigeria, most of the damage already has been done. It breaks in the years before the courtroom, and then it breaks again in the first 48 hours after arrest. They're distinguished partners in our collective progress. Nigeria is not starting from zero. We're a nation that has, in law, already chosen the child. And a speech about justice for children owes this bar, chapter, and verse. Nigeria ratified the Convention on the Rights of Child in 1991 and the African Charter on the Rights and Welfare of the Child in 2001. With the Beijing, Riyadh, Havana rules, all converge on one principle: detention must be the last resort for the shorter possible time. Our own law says the same. The Section 1 of the Child Rights Act makes the best interest of the child paramount. Section 205 protects the child's privacy. Section 209 lets the police and prosecutors dispose of a case without formal trial and is our statutory foundation for diversion. Section 212 restricts detention pending trial. Section 214 and 215 guarantee fair hearing and set the do no harm standards. So the honest question this conference must answer is not whether the law exists. It is why a child in many parts of the country today still cannot feel protected. Distinguished ladies and gentlemen, let me put my central position plainly. The child in conflict with the law is overwhelmingly a child whom another system failed first. She's the child never registered at birth, and so cannot prove she's a child. He's the boy who left school in primary 4 and found the streets before the streets found him. She's the girl who married at 15, who ran, and who was treated as vagrancy. He's the child whose family collapsed and for whom no social welfare officer was ever assigned because in his local government there was simply none. Dear learned colleagues, dwell with me on the first of those, because for a legal audience, it is the master problem. Only about half of Nigerian children under 5 have had their births registered. Age is the gateway to every protection the Act confers. A person who cannot prove she's a child is processed as an adult. She's charged in an ordinary court and remanded in an adult facility. She loses the closed proceedings, the diversion option, and the presumption of family reunification. Every safeguard turns on a fact she cannot prove. Learned colleagues, most of these are not cases of bad faith. They are cases of missing papers. Now, the numbers I asked this conference to adopt as its baseline. About 26,000 children enter custodial and remand facilities every single year in Nigeria. Over 122,000 in 5 years. Nearly 74% wait in pretrial detention without a timely hearing opportunity. And some 68% have no lawyer from the first contact. Those 3 figures describe one pathology. The 68% tells us failure is front-loaded before charge, and the 74% tells us remand has become our default rather than our exception. And the 26,000 tells us diversion is not working. Learned colleagues, let me be precise, because Section 204 exists, and I have just cited it. Our difficulty is not the absence of a statutory book, it's the absence of a framework around it. No prescribed menu of options, no eligibility criteria, no mandatory recording that makes discretion auditable, no review. What we have instead is discretion, exercised well by officers and magistrates of goodwill. And I record my respect for them. But discretion exercised well by good people is not a system. It's simply luck. 2 further structural facts. Nigeria still holds one of the lowest age of criminal responsibility in the world. You heard my sister, the professor, when she strongly and passionately presented it. At 7 years, it's simply not acceptable. I state my position plainly. 7 years is indefensible in 2026. It is inconsistent with our treaty obligations. It should be raised immediately. Second, our family courts exist more securely in the Act than in our court buildings. In many places, what sits is an ordinary magistrate court under a different name. Distinguished guests, ladies and gentlemen, let me account for what has been built in response. Under the renewed hope agenda of His Excellency, Mr. President, President Bola Ahmed Tinubu, GCFR, he has declared the year 2026 as the year for family and social development. And by 2027, it is my hope that we'll do enough work so that Mr. President can declare it the decade of the family. This is not ceremonial. This is not ceremonial. A child in conflict with the law is almost adoption because our own procedural failure created the market for baby factories. By making the lawful route slow and unlawful route fast, the revised National Child Policy and the landmark National Boy-Child Policy, most of the 26,000 children in custody each year are boys. And any strategy that speaks only to the girl child will miss out the children in the cells. The NBA president, other learned colleagues, with the Federal Ministry of Justice, we're driving statutory review of the Child Rights Act and the Violence Against Persons Prohibition Act of 2015. The Child Rights Act is that of 2003. I use this platform to formally invite this association to submit technical memorandums to those reviews and to our forthcoming third generation gender policy. I'm not asking for endorsements. I'm asking for drafting scrutiny that only practitioners like you can give. I would rather give it now than read it in a judgment in 4 years' time. I will not pretend that the picture is complete. In a country of over 230 million people, we operate about just 52 sexual assault referral centers across 25 states and the Federal Capital Territory. 11 states have none. The forensic windows closes before the nearest center can be reached, and with it closes the prosecution. 4%, I put that to a room of lawyers deliberately. It is not a welfare statistics. It's a justice sector output. It is the clearest measure of the distance between our statute book and our practice. A survivor who reports and is not vindicated teaches the next survivor to not even bother. Distinguished ladies and gentlemen, permit me one further appeal to the administrators of our remand homes and Bostal institutions, a facility that holds a child without education, training, or recreation is not correcting him. It is hardening the child and returning him to the same streets at 18 with a record and without a skill. These places must become sanctuaries of rehabilitation, not sites of confinement. So what remains outstanding? In the full paper, which I have circulated, I set out 7 reforms. This morning, I'll speak about 5. The first is to raise the age of criminal responsibility. Secondly, is to constitute the family courts in substance, not in name. Thirdly, is to build a framework that makes Section 209 unusable. Fourth, is to give every apprehended child a lawyer within 24 hours. And the fifth is to establish that where age is in doubt, the benefit of that doubt should go to the child. Thank you. Mr. President of the Bar, distinguished members of this association, this brings me to the part that matters the most. Our ministry, my ministry, can advance the policy, the standards, the welfare infrastructure. But some things no ministry can do. Only the bar can put a lawyer beside a child in a police station tonight. Only the bar can bring the test case that settles the presumption of minority. I therefore make 5 humble requests. The first is to operationalize the duty solicitor scheme in every branch, not as a resolution, but as a rota. A named lawyer on a call per division, with the rota lodged with the divisional police officer and the legal aid council. If this conference achieved nothing else, moving that 68% will justify the whole week that we have spent here. Secondly, is to treat early legal assistance as professional duty and not as charity. No child should spend a night in a cell without being told, in the language he understands, why he is there and what happens next. May I ask each member for one child justice or gender-based violence matter a year. With the number of lawyers on this role, that single commitment exceeds anything my ministry could procure with any budget. Thirdly, to institutionalize training through the Institute of Continuing Legal Education, to train our lawyers, our prosecutors, the police prosecutors, on the mechanics of diversion under Section 209, on the trauma-informed child interviewing, and on restorative practice. Let the rights exist as skill in the courtroom, not merely as a text in our statute book. The fourth is to partner with us on mobile family and children's court in the rural and underserved areas. With the National Judicial Council and the state judiciaries, may I propose that we launch the first cohort during the 16 days of activism, which is between the 25th of November to the 10th of December this year, selecting jurisdiction on remand data rather than on convenience. The fifth is that we must litigate. At least 4 questions here are one well-argued case away from resolution. The presumption of minority where age is unresolved, the lawfulness of remanding children in adult facilities, the fair guarantee for a child held without hearing, and the standard of care owned by an unregistered residential facility. My ministry cannot bring those cases, the association can, and where it does, will provide the data and the evidence. Distinguished colleagues, ladies and gentlemen, I also make one offer. May I propose that this association and my ministry conclude a formal compact on child justice with a joint technical committee, quarterly reporting, and 4 published indicators, including child reached by a lawyer within 24 hours, children diverted from custody, functioning family court sittings per judicial division, and pro bono child justice matter concluded. Distinguished members of the bar, as I prepare to close, may I reiterate that in my years as the DG in APTIP, later as the Federal Commissioner for the National Commission for Refugee, Migrants, and IDPs, I met many children whose first real encounter with the Nigerian state was not a school. It wasn't a clinic or a social worker. Their first encounter was a uniform. By the time the state arrived, its only remaining instrument was cohesion. Every other instrument had failed to reach them in their earlier years. That is the sequence this session exists to break. I ask of each of you to remember this. The child standing before a courtroom is not a smaller adult. That child is a citizen still becoming. The manner of our justice today determines the manner of citizens Nigerians receive tomorrow. A child saved from unnecessary custody today is a teacher, a doctor, an engineer, a judge, and indeed a future president of this bar. May I reiterate that the Federal Ministry of Human Affairs and Social Development and the Nigerian Bar Association share a critical responsibility for advancing justice, protection, inclusion, and empowerment of women, children, and other vulnerable groups. This shared mandate is anchored in the Nigerians' commitment under the key international and regional instruments, including the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW, of 1997, the Convention on the Rights of Child, CRC, of 1989, the African Charter on Human and People's Rights of 1981, the Protocol to the African Charter on the Rights of Women in Africa, the Maputo Protocol of 2003, the African Charter on the Rights of Welfare of Children, the ACRWC of 1980, and the Beijing Declaration and Platform for Action of 1995, and under the Nigerian Security Council Resolution 1325 on Women, Peace and Security of the year 2000. Accordingly, a strong institutional partnership between the Ministry and the NBA can strengthen access to justice and legal aid. It can promote effective implementation of the gender and child-related legislations. It can support survivors of gender-based violence. It can enhance legal awareness, strengthen accountability mechanism, and contribute effectively to the implementation of instruments such as the VAP Act of 2015 and the CRC and the CRA of 2003, both undergoing review. Such collaboration will help bridge the gap between Nigerians' international commitments, national laws and policies, and the actual outcomes, ensuring that women, children, our families, and the vulnerable population enjoy meaningful protection, justice, dignity, and opportunities in line with the renewed agenda of the federal government of Nigeria. The theme of this conference is Beyond Limits. Our limits here are not in our status, and certainly not in the equality of the Nigerian lawyer. They are in the reach, in the coordination, in the ordinary discipline of making a right walk at 3 o'clock in the morning. Those are limits we can pass, and we can begin this week. Our ministry brings its policy architecture, its instruments, and its presence in 774 local government areas. This association brings the one thing no ministry can supply: a lawyer beside a child. Together, we ensure that justice is for every child. Mr. President, under the renewed agenda for children, remains committed to ensuring that we uphold the welfare and the well-being of the Nigerian child. I wish us all a rewarding session. I thank you all for listening. May God bless the Nigerian Bar Association. May God bless the Nigerian child and the other people that we serve from my ministry, the women, the families, the vulnerable population, and may God bless the Federal Republic of Nigeria. I thank you for the opportunity.
Thank you. Thank you so much, Honorable Minister, for those very powerful remarks. Your leadership really reminds us that the justice for children is not only about the law, it's about protection, care, recovery, family, and the opportunity to rebuild the future. Thank you all distinguished speakers for setting a strong direction for this work ahead. So now, ladies and gentlemen, this really marks the end of our session. We're now going to go ahead and present some souvenirs to the Honorable Minister. I would like to call upon Mr. Abdul Muhammad, SAN, Chairman of the NBA Annual General Conference Planning Committee, to present the souvenir to the Honorable Minister, followed by a photo session. Following that, I also welcome the Chief Emeka Ebogoli, SAN, apologies if I've not pronounced your name correctly, to present the souvenirs to the rest of the panelists of the earlier session. So welcome, Mr. Muhammad. Where is he?
The Honorable Minister is very accessible. You could direct the questions, and we'll provide a link where you can do that, and she will respond. Thank you very much.
The work is ongoing. I'm not going to run anywhere. We've already agreed to work closely together for the Nigerian child. So I'm happy to answer questions, because in answering those questions, we'll be able to forge a strong path ahead. I'm very accessible. The ministry is open to us all. It's the most beautiful building in Abuja. So I want to also be known for doing beautiful things. So you're welcome to the ministry anytime.
On behalf of the Nigerian Bar Association, we thank you, Honorable Minister Ma, for gracing our occasion, and we give this small token in appreciation. Thank you very much, ma'am. Yes, ma'am. May I invite the President of the Nigerian Bar? Thank you very much, ma, for this. This is our souvenir and a unique bag for your use. You will love it. It is made in Nigeria. By a Nigerian woman. Yes, thank you very much, ma. And you came at the auspicious time when we elected a Nigerian woman as the president of the Nigerian Bar Association. Thank you for honoring us. Thank you.
Thank you very much. Dear ladies and gentlemen, please scan this QR code to access the address of the Honorable Minister. There are a lot of points and call to action that we need to take forward, so please do that.
On behalf of the Nigerian Bar Association, we thank UNICEF for partnering with us, and we assure you that going forward, the desires of the minister to have a child by the side of a lawyer before a police station, a court of law or something will be achieved based on this partnership. A lawyer by the side of a child at a police station in a court of law will be achieved by this partnership. Please take this in appreciation of your partnership with us. You're welcome. Yes. Yes, ma'am. Yes, ma'am. And we have a souvenir for you. It's made by a woman. This bag is made by a Nigerian woman. Wow. Yes, and it's beautiful. Oh, yeah. Thank you very much for. Yes, ma'am.
I accept this on behalf of the office, so thank you.
All right, thank you. Yes. The Honorable Minister for Justice, ably represented, please accept this token on behalf of the Nigerian Bar Association for honoring us at this auspicious event where we talk about the future of our country. Children are the future, the leaders of tomorrow, and your coming really made it show that the government do in fact believe in that. Thank you very much for honoring us, ma'am. Thank you much.
Thank you very much. The Honorable Attorney General of the Federation is so passionate about children, so I'm sure that we're going to move fast with the amendment of the Child Rights Act and pass it as soon as possible too. Thank you very much.
Who else? No, we've given nothing. Yeah. So please, we'll just have a photo ops and then we're done. Please, the panelists should come up for the first technical show. Thank you very much. Thank you. Thank you.
Thank you. You are reminded that we have the QR code available for you to access the speech of the Honorable Minister. And also in the booklet, there is another QR code. If you're interested to provide pro bono services, please scan that and register yourself. Some of you may have already registered last year, but we're still encouraging for those who haven't registered to please register yourselves, and more information is to follow through this partnership between UNICEF and the Nigeria Bar Association. Thank you, and I wish you a very fruitful deliberation for the next session.
Good morning, ladies and gentlemen. Leonard Silks present. Colleagues, I welcome you to the next session on business of fees. And in particular, other halls are currently occupied with other running sessions. So I ask everyone to be well seated to enjoy the session. And on this note, I warmly welcome our distinguished speakers, panel members, seasoned practitioners who would be doing justice to this particular and timely session and topic. I would like to welcome members of the panel, our moderator, Mr. Emeka Obegolu, Senior Advocate of Nigeria, who will be steering this conversation. And on this panel, those who will be joining him will be Mr. Bode Olanikpekun, Senior Advocate of Nigeria, Mrs. Chinyere Okorocha, Mr. Obegolu SAN. You're welcome, sir. I would like to also welcome Mr. Ikechukwu Ekweme, Ms. Aisha Ado Abdullahi, and also Mr. Isdo Oswo. Please give them a round of applause. Okay. You have your names there. Do we have Mrs. Chinyere Okorocha in our midst to join us on stage? Mrs. Chinyere Okorocha. I'm sure she will join us shortly. So I will be handing over to our moderator who will take it to the next level. Thank you, and I hope you enjoy the session.
The President of the Nigerian Bar Association, past presidents here present, very distinguished colleagues, let me ask us to please be seated. This session is the bread and butter of the legal profession, particularly those who are in private legal practice. We all know that since the 2023, the remuneration order was signed into law to regulate the professional fees for services rendered by legal practitioners. For those of us, first let me ask us, if you have a copy of the remuneration order 2023, please can you indicate by raising your hand? Well, it's apparent that less than 20% of us in this hall have a copy. Now, if you have read that order, can you also indicate by raising your hands? Wow, thank you very much. And for those who don't have a copy, please go to the NBA website and download for yourself a copy of what, in my view and in the view of some of us who have read it, is the singular most important instrument that strikes to the welfare of legal practitioners. Now, that order was signed into law in 2023, but the administration of Mazi Afamosigwe SAN has decided to put this order on the front burner of issues agitating the minds of lawyers. That was why, upon his inauguration, he inaugurated the Remuneration Committee of the Nigerian Bar Association. And I must also thank the NBA section on legal practice, who thought it wise to also place this order and issues around legal practice on the front burner. So today, we are going to be discussing amongst ourselves issues around enforcement practice. Of course, the order is self-enforcing, but the part of this panel will be to answer some of the questions that from our work as a committee, it's agitating the minds of our members. Particularly, how will lawyers determine what to charge? Especially when it affects relatives, old clients, and so on and so forth. How do you determine your charges? Why do clients resist legal fees? We're going to be asking ourselves, from our individual experiences, particularly from this panel, why do you think clients resist legal fees? What pricing models exist, and how do we utilize these models to serve our purpose? And how can lawyers avoid fee disputes? Most times, we end up in court with our clients, litigating fees that will end in litigation, will end up litigating it. So, are there ways to avoid fee disputes? What systems can help us collect our fees more effectively? And more importantly, how can we improve profitability without compromising on our ethics? Distinguished colleagues, to throw light and share their experience on these issues, we have Mr. Bode Olanibeku, Senior Advocate of Nigeria. Can we give him a round of applause? We have Ike Chukwu Ekweme, Esquire. We have Aisha Ado Abdullahi. And of course, we have Isdore Ozuo. Now, I'm told that Chinyere Okorocha is somewhere around. She had been sending messages earlier, trying to get the location. But we await her arrival. So, this is going to be a conversation. As many of us who have had experiences, there will be enough period for questions and answers. We would like to hear from us on the challenges we face, whether while implementing the order or while freestyling. But it's important to know at this conference that the remuneration order is enforceable. The branches of the Nigerian Bar Association have mandate from the National Executive Council to enforce this order. As we speak, the Remuneration Committee of the NBA are entertaining some petitions against lawyers. In the next few days, you will hear the report of the Remuneration Committee to the AGM. We'll tell AGM how far we have gone, and if there are lawyers we think may be culpable, we will recommend them to the disciplinary committee of the body of benchers. So on this note, distinguished ladies and gentlemen, I think I can now sit down and fire a few questions. I'll be asking you guys questions, and I expect practice experience. I don't want case law. I want more of practice experience to help us navigate this issue. So let me go to Mr. Bode. Mr. Olanibeku. You see, the practice, there's a culture of legal practitioners who rely mostly on their past experience with their clients, and that leads to frustration in billing. So, how much risk does this pose?
The client was not talking to all the law firms that were dealing with the bigger issue. And I took up the client to say, look, what exactly is happening? Don't you want us, how do you want us to deal with these outstanding issues or these issues that are now developing from the main issue? I see that you're only inviting select law firms to meetings. And the client passed a comment about a particular law firm, said, oh, well, I don't want that law firm on my instructions again. And I asked why. And he said, or the client said, or the legal advisor of the client said to me, the first conversation that lawyer has every time we discuss is about his fees. I was a bit taken aback, and I said, well, is that not an important conversation? And the legal advisor said to me that, look, let us say, we've been working with this particular firm for over 10 years. And in 10 years, the first conversation they always have with us is about their fees. That's so we don't think that our business is important to them. So to look at the question, sir, looking at past relationships, existing work to deal and balance it with issues of fees, it's very important for us as lawyers to return clients because, I mean, that's also a test of our capacity, how much return work clients bring to us. But you see, we must really balance that, managing the relationship with fee avoidance. So I think the issue really stems on where does fee conversation border on insensitivity, and where again does it cross the line to fee avoidance. Under the new regime of the remuneration order, it says that we must discuss financial terms within 14 days of receiving instructions. Again, I'll leave it to this session as to if that is practical, if that is realistic, if that works. It's for us to decide. But I'll land it here, because what exactly is risk? I mean, from what we learn in business school, our management trainings, it's what could go wrong? That's the question we should ask. What could go wrong in this relationship? What could go wrong in the past? There are some clients that it will be an embarrassment to them if they had a fee dispute with their counsel. So with those type of clients, you can sort of be a little bit more relaxed. Whereas there are clients that might not go that route. So I'll land it as that familiarity with a client should not mean that a fee conversation is unnecessary. As a matter of fact, familiarity with a client should make the fee conversation easier. But I don't also agree that that should be the first conversation. Thank you.
Thank you very much, Bode. Can we give him a round of applause? You know, this is a very difficult conversation for some lawyers, and I think what we don't do at the law school is to teach law students how to charge fees. And there's a science or technology around charging fees, particularly with the mindset of a client. And if you know your client very well, you may be able to charge fees appropriately. So thank you, Bode, for sharing your experience. Madam Chinyere, you just arrived. I'll take you straight into the deep sea. The order provides a minimum, a threshold for fees. There's no maximum for fees. So I also have come across some jurisdictions. Of course, we know that the average client doesn't want to pay a lawyer. So in some jurisdictions, you see millionaires, when they want to go to a lawyer's office, they take a bike to go so that the lawyer will perceive them as a pauper. So every client in the average wants to avoid paying commensurate fees. So Chinyere, in your experience, how should a lawyer determine the right price for a legal mandate or a brief without either underpricing the work or pricing themselves out of the market?
Thank you, Leonard Silk. Good afternoon, distinguished colleagues, and my apologies for arriving late. As you know, I'm an immediate past chair of the Women's Forum, and I had an obligation there and quickly rushed over when we now started, but I apologize for coming in late. So the business of fees, oh my God, it is such a sensitive topic for lawyers in particular. But what we need to understand is that law is a business. Yes, it's a professional service, but it's also a business. So instead of us as lawyers asking, what should I charge? Maybe we should be asking, of what value is this service to my client? And what exactly will it cost me as a lawyer to deliver the service to the client, given that I've got bills to pay? The problem really originated from the origins of the legal profession. We all know that we borrowed this, our legal profession, the culture, everything about it from the UK system, where when law started, it really was like a social sort of function, which wasn't even paid for. And so I think have all made us begin to realize that it's not a social service, it's a business, and we need to get paid. So to cut to the chase, I have 5 things we should consider when we want to bill our clients. And the very first thing is to understand the scope. Understand the scope of the brief. Sometimes we just rush to give a price, meanwhile we haven't scoped it. You haven't determined what we are playing. This is the type of work that must be done by a senior lawyer, a partner, or an SAM. Can an OCC deliver it? How much time will be spent on it? What's the cost to my practice? What thing we must determine. The second thing is to know exactly the cost to you. As a law firm, you do have overhead costs. The cost of delivering services, all right, are shared across the firm. So there's your rent, there's your electricity, there's your solar system, if you have one, there's the cost of diesel, there's the other infrastructure around your firm, there's the cost of your lawyers, and so on and so forth. You have to know what exactly your clients. So please do not rush to give an amount first. Scope it well and determine exactly the cost to you as a practice so that you can remain profitable. There's so many situations where at the end of the day, by the time the matter is so long drawn out, that you end up making nothing at the end of the day. So it might be a 20 million brief, but at the end of the day, nothing is left for you. You have paid expenses all the way. The third point, because I know we're looking at the clock, you have to look at the complexity of the matter and the risk to the client. You see, all problems are not equal. Let me put it like that. All problems to a client are not equal. If the problem you are about to solve for that client is a problem that can cost the shutdown of, say, a 10 billion or 100 billion naira, let us say, business, and they will shut down your offices, and they call you a lawyer to solve that problem, it's completely different from a normal routine matter. So I truly believe that in costing your services, you have to put into consideration the complexity of the matter and the fact that this one is quite, is a situation where the client may be at risk if you don't solve the case. And I assure you, in cases where the risk to the client is really high, they're willing to pay anything to get out of it. Or they're willing to pay, let us say, a premium if they understand or acknowledge that you can help them solve the problem. Number 4 is that you should price your expertise. and not simply your time. We all know about hierarchy at the bar, and I truly believe in the principle. What a 10-year at the bar lawyer knows, or indeed a senior advocate of Nigeria, is different from what or the expertise of a 1 year at the bar person.
So, Chinyere is saying to us that law practice is a business, that until you see your practice as a business, you may not be able to utilize the business skills needed to transform your practice to a profit-making venture. Now, Aisha, we know that the remuneration order provides extensively for the principles and scales for charging of these fees. Can you tell us in practical terms how we can translate those principles into actual fee proposals for our clients?
Thank you very much. Thank you very much, Mr. Moderator. Good afternoon, distinguished seniors and colleagues. So, since you particularly stated practical terms, I want to begin with my early years in practice when I consult my seniors and ask them the question, please, how do you charge for legal services? How can I learn from you? I've had many seniors, and oftentimes I get one common response. They would tell me, well, start with looking at their wristwatch, their shoes, the kind of vehicle that they are riding. That can be a starting point. But of course, I'm sure the seniors and most of our colleagues here know that that is not the case. The moderator mentioned it earlier, like in the jurisdiction where I started my practice in Kano. If you use that, you will lose, because there are a lot of men that go about, some of them riding bicycles with tattered shoes, but you may end up discovering that they own a quarter of the properties in Kano. So don't use that. I was so glad that at least we now have the remuneration order. It is at least there to help us. It's a framework to help us to begin to charge at least professionally. It is not providing orders. It's called an order, but it's not saying this is exactly what you must charge. No, it is there as a regulatory framework to give us structure, to have us price our legal services professionally, providing fairness, of course. So it is important. This order is, I am very surprised, maybe concerned, that when the moderator asks us to show by hands how many of us have the remuneration order, have a copy, it was less than 20%. Please, colleagues, I implore you to get the copy, study it. It helps us to begin to price. We always think about how to make money. One of the challenges that we've been facing is that right from school, we are taught law. We are taught to be professionals. We are not taught to be business people. When we discuss legal practice, we usually discuss the law, how to advise clients better, how to win cases, how to prepare better agreements and briefs. But then we run offices, we pay salaries, we manage our offices. We have to now begin to think about ourselves, not just as professionals, but also as people in business, as business people. So to answer the question, how do we charge? If we look at the order, we would see that we're given practical steps that would guide us. The minimum is provided. It's the minimum. It's how you begin to look at the value of the service you are offering, of your experience, of your time, of your expertise. So I would suggest, or I would advise, based on the guide that we have in the order, that we use 5 practical steps. Number one is to identify or understand from the instruction your client is giving you, what exactly are your actions? So it is there. The categories are based on, of course, our years of practice, and of course, it also categorizes the services based on locations that are categorized in bands. So we have so much that we can take on that would help us. Once you have identified the service, you check the order, check the relevant scale or category, look at whether you are an SAN, and also your location of practice. The next step is to scope the service that you are rendering. We make a mistake, especially those of us that are growing, the younger ones. When you are charging or you are pricing, you write to your client that I'm charging, for example, 1 million naira. Professional fees, 1 million naira, which is kind of sometimes the reason why our clients will kick against the figures. So we need to scope and state exactly what you are doing, what the client would expect of you. For example, you may have the description stating that, yes, our professional services requires legal research, document review, negotiations, drafting of agreements, meetings, and of course, presenting of the final executed document. This would give not just the client, but even you as the lawyer, clarity on the service that you are providing. And then the next step, that is the fourth step, is for you to cost or price the service. You have to understand that the order has gone as far as providing factors that you may use in pricing the service. You may consider the complexity or novelty of the matter, the depth of research or legal due diligence that will be required. You may consider the requirement or either you may need specialized services, yes, or to have an expert to help review the documents or consult with. There are so many factors that you must consider that would help you, of course, with the skills that have been provided to know how to charge. And then last but not the least, and very importantly, you put everything in writing. We make a mistake sometimes of engaging in phone conversations with clients or friends that on that phone call, you would give the legal advice freely without knowing, and then expect them to come and meet you. You may call them to say that, okay, yes, so this is what we may do, but meet me in my office. Meanwhile, you've already given the advice, and they'll just go ahead. Sometimes even use AI to know what the steps they need to do, and they'll just go ahead and do it. So it's important to consider that. And when you are presenting the fees, it is advisable to present it in a form of fee proposal, which will state all that the client is expected to understand that you are providing. And very importantly, also state exactly when you expect to be paid. What we usually, overlook is the fact that we are not just presenting a document with figures just because we are engaged by the client. What we are presenting is the value of what we are providing, the value of the time you are spending, the value of your expertise, the value of your experience, the value of the responsibility that you are taking on behalf of your client. So you have to put that in mind and factor that in your pricing. We have excellent lawyers with practice that is really not financially sustained or sustainable. And it's all because we have not averted our minds to the fact that we need to think about legal practice also as a business and find ways to make it sustainable. There's nothing wrong in wanting a legal practice that is commercially profitable. And of course, we have to keep in mind our professional and ethical obligations. Thank you.
Thank you very much, Aisha. Aisha has told us to ensure that you have a shared understanding with your client on the brief you have received. Until you have a shared understanding with your client, it will be difficult to communicate fees effectively. Thank you very much. So that will take us to Isdor. So, from experience, a lot of money or fees are lost between billing and collection. You send a bill to your client, even when the client accepts or doesn't respond to your bill, he makes a deposit payment to you. In between that bill and the collection, a lot of money will be lost. Do we have systems in place that can help the lawyer to address this gap in the system? Is it possible for those systems to be deployed to the benefit of lawyers?
Okay, thank you, Len. Okay, I will prefer that. Yes. Yes. Okay. Thank you, Leonard Sik, for. Is it not okay? Hello. Let's see. Thank you, Leonard Sik, for the question. And good afternoon, distinguished seniors and colleagues. The first thing from the question, law firms are losing money, and are there systems to help them not to lose money? So to approach this, I will answer how or why are law firms losing money and the systems that will help us to stop losing money. The first comment I will make is that lack of profitability in legal practice is not as a result of lack of work or poor legal strategy, but that friction between billing and collection. So that all of us here can testify that we have something to do almost at every point in time. We are busy, but are we profitable? So for that profitability to happen, everyone here must understand the process from intake to cash, from instruction to the money in your pocket. What are the stages involved? Because when you get these stages, you now know how you are losing money and how the system can help you. I will propose, I think there are principally 4 stages. The first is the contracting or the onboarding stage. The second stage is the work stage. The third stage is the fee notes or invoicing stage. And the fourth stage is the collection stage. So, lawyers lose money in all 4 stages. How? For the contracting stage, thankfully, we all mentioned that the remuneration order has helped lawyers now. Paragraph 7 of that order says, before you start the work, or within 14 days of receiving the instruction, that we should do is that we must include at the contracting stage, of course, the fees. And even the order says, if the fees are not ascertainable, say so, that the fees are not ascertainable at this stage. But again, what we miss out sometimes is the payment schedule. When will this fee be paid? The payment milestone. What will I do and I'll be entitled to fee? We should include that at that contracting stage, because if you don't do that, you lose money. Beyond this point, the fee talked about interest. Charging interest. Yes, it is not a sin. It's not an unprofessional conduct to charge your client interest because you are rendering services. So there was, I think last year, we were involved in a matter with the UK firm. When they sent the letter of the engagement letter, it was clearly stated that they are entitled to charge interest They are entitled to charge interest based on the Judgment Enforcement Act of 1884. The clearly written, which talks about 8%, and that law is actually applicable in Nigeria by virtue of the Interpretation Act, Section 32. So we should have that. We should also have the right to stop work order, whatever it is, that you are not going to proceed if fees are not paid. So at that contracting stage, we should tie up all these loose ends so that we don't lose money. At the work stage, it depends on the work you are doing, if it's hourly rates, if it is percentage billing, if it is contingency. For that, for instance, hourly rates, most persons don't capture the hours in real time. It's after doing the work, they now come back and say, that work we did last month, how many hours are we going to be the client? You don't ask how many hours are you going to be the client. You should already know how many hours you've worked. So if you forget to capture your time in real time, you are bound to lose money because you're not billing properly. For the contingency arrangement or the fixed fee, the problem with that is during the work stage, invoicing stage, people also lose money. For instance, hourly rates, you even discount the invoice before it gets to the client. You tell us, this is 50 hours, this is too much, let's give the client that. No, just put in the hours first. Let the clients come back and you negotiate. So don't even discount the invoice before you send it out. Another problem with that invoicing stage is the issue of lack of clarity in describing the work you've done, or you are not issuing your invoice immediately the work is performed. Because if you do it much later, the client may have forgotten the value you created. So these are some of the issues. Then the last stage is the collection stage. You've gotten all this right. How is your collection done? Is there a timeline for reminders? Who owns this process? Is there a person designated to chase after a particular client? If you issue invoice today, if it is not paid within 7 days, what happens? So if there is no protocol on collection, lawyers are bound to lose fees. So the question then is, are there systems in place to help? Of course, there are. The systems in place will be the ones that will address all stages. So a law firm should be in a position to have a matter, what I call it, or matter number, whatever basis, a checklist of how you onboard a client, what needs to be done. Is there a system for time capture? If you are doing a work, can it be captured in real time? That system needs to be deployed. Sharing an experience, in my former firm, when that system was first deployed, it was difficult because they deployed it in such a way that whatever you are doing on your system is captured in real time. So that if you are idle, after 2 hours, the system will prompt you. You've been idle for 2 hours. Do you want to record it? So that it is that, for some of us that were there before the deployment, we struggled with that system because it was trying to capture the real time that we spend on any particular work. So, interestingly, in Nigeria, we have local softwares that are now helping out in all these processes. I'm not going to talk about the foreign softwares, but they are local softwares. Some of them actually at the close the booth or whatever, marketing these services. So it is for us to deploy them. When I went there, I moved around, checked some of the solutions. We have the Module Law, we have Nest Council, we have Law Pavilion Elite, we have one is One Chambers AI, and one is Due Law, something like that. So it is for us to look at these systems and see the one that will help us in all the 4 stages that we are losing money. I think I will stop here for now. Thank you very much.
Thank you very much. What ISDO has told us is to convey your fees to your client in a clear and concise manner so that the client will understand what he is paying for and what stages he will be needing to pay. So thank you very much. But we also know from my experience that even when you convey these fees, we still meet resistance from clients. So, Mr. Kweme, please, coming from the client perspective, can you share with us maybe some of the reasons why clients resist payment of fees? Is it as a result of the volume of fee requested, or clarity as to what clients need to pay for? Please, can you share your thoughts on that?
Thank you for that question. And business of fees. Good afternoon, colleagues, and I'm happy to be here. And moderator, before I jump into the question, I have a few interventions on the last two presenters' comment, which I fully agree. But bottom line up front, I want to say these things. The remuneration order is clear in terms of setting the remuneration framework. It recognizes the complexity and the different value that we bring to the table in terms of work we deliver. And most importantly, in my view, injects a greater discipline around pricing and scope. But I must say, and I'm very intentional about this, the remuneration order in itself alone cannot make lawyers profitable, bottom line. And I will touch on that. That's why I like the intervention from ISDO in terms of the practical steps that needs to be taken in terms of ensuring profitability. The other point I also want to touch upon is the fact that discussing fee and scope upfront, beyond being provided by Section 2 of the order, is actually a demonstration of professionalism. The sentiments around, are you putting money up front, are you discussing it at some point, ends up creating that dispute and that challenge that leads into the question I've been asked to intervene today, which is, what are the real reasons why clients resist legal fees? Is it the amount charged or the scope to risk? And most importantly, the engagement or the interaction between the lawyer and the client shouldn't be the lawyer coming up to the table to justify, demonstrate efforts. Discussions that are anchored on efforts will not cut it. The focus clearly must be on the value that underpins the invoice that is being asked to pay. So the fact that lawyers say I spent 50 hours, the client will say I don't understand what these 50 hours means in the context of the output that you've presented. So what does that mean? It means that the lawyer must spend a bit of time to describe the risk, connect it with the client's objective. If there are regulatory exposures that we are managed, to bring it on the table. And most importantly, find a way of making that value visible. And also to add that it's important to note that as work is being done, especially where scope starts changing, prompt engagement, prompt communication is clear. The client is not going to be very comfortable just understanding the scope change at the end of the day when the invoice has been presented. You're actually going to take the client through the journey, what is done. That's where regular update helps in terms of identifying the additional scope that the lawyer delivered in the context of that work. So in terms of the second part of the question, which is around the structure and how we communicate fees, fee disputes is basically expectation disputes that started at the beginning of the engagement. what the instruction is about? Is the client thinking about something else? What is the agreed scope? Are there circumstances that might engender scope creeping? So to better underpin this and ensure disputes avoided at the end of the day, there must be that agreement. There must be a fee note. There must be an engagement letter. And you mentioned it, clarifying what the client is, what the lawyer is being asked to do, the assumptions, to make sure that we have an alignment of assumptions. What pricing model are we going to deploy? Are there potential for scope change? How do we treat scope change? And if additional work comes up, how should it be paid? So what I see is that the engagement letter and the fee discussion up front represents a clear commercial roadmap that governs the relationship between the client and the lawyer through the entire period and the lifespan of the brief. And if that is clearly managed well and properly documented, there's actually largely no room for client pushing back or maybe discussions or disputes around fees. So I will hold it there. The conversation is, for me, about managing that commercial roadmap that underpins the relationship between the client and the external counsel, making sure that the scope is clear, making sure that the deliverable is clear, making sure that the fees and amounts to be paid are clear, and the time for delivery. And if there are potential for scope change, that it is agreed upfront what will happen and how will be paid when that happens. Thank you.
Thank you very much, Ikechukwu. But let us know that, yes, Ikechukwu has said that the remuneration order on its own may not elevate the welfare of lawyers or increase our take. But I have good news for you, Ikechukwu. Currently, as we speak, our branches, that the remuneration order has strengthened the hands of young lawyers who can now charge very well. Then who used to consult me and send briefs to me stopped sending briefs to me, because I stated clearly that if we have any in-house counsel instructs a lawyer and prescribes a fee below the scale threshold, that I will personally refer the in-house counsel to the disciplinary committee of the body of benchers as provided under the order. So we are firm that even INEC, we wrote to INEC and we said, look, we know your regular schedule of fees for lawyers, but at this time we have a regulation that prescribes what you cannot charge below. And we hope that we are watching for the next batch of election petitions to see what they instruct lawyers with. But having said that, I thank you.
Mr. Moderator, do you want me to clarify a bit?
No, well, I'll get back to you on that.
I'm actually fully aligned with you. What I'm saying is remuneration order plus the important points that he has made about how you invoice, how you contract, how you collect actually makes the difference. Standing alone requires the extra effort he has also identified, including the efficiency in terms of deployment of technology. I just wanted, so fully supported, remuneration order, very good.
I would probably have preferred to be in the audience so that I'll throw a question at my brother Ikechukwu, but probably I'll use speaker privilege to say that, look, when you talk about value measurement, you know, the truth of the matter is that most times it's the lawyer that actually knows the exact amount of effort that he puts into any instruction. So when clients talk about value, how exactly do you measure that value? Is it by outcomes? Especially when the outcomes don't meet the expectations of a client in dispute resolution, which again is why, from a place of principle, I make it clear that there are no guarantees of outcomes. In any event, giving guarantees of outcomes in itself is professional misconduct. So we should be clear about what value measurement is as compared to efforts that have gone in. And
that will, in fact, also lead into the Indoma Egba and First Bank situation. And I believe that every lawyer that earns a living from providing solutions by providing legal services should read Indoma Egba and First Bank because it's a case where I actually believe that the lawyer suffered a loss. In that decision, there were two issues for determination at the Court of Appeal. Of course, there was a fee dispute between Senator Indoma Egba, now SAN, and his client then, First Bank, who had briefed his law firm to recover about 39 million naira in 1992. For context, at that time, that was about somewhere around $4 million US, or, verging on $5 million US. So, Egba's firm was insufficient in particulars because the bill simply said to professional fees being 15% of 38 million naira. And the Court of Appeal said, no. That cannot satisfy the specifics of the Legal Practitioners Act as to what a bill of charges must contain. And it was really a sad scenario because in that situation, there was a letter of instruction and there was a letter of acceptance. So there was clear offer and acceptance. But unfortunately, action for recovery of fees. Very sad, very painful. But it's a decision all of us must familiarize ourselves with. And also, there's another decision of the Supreme Court. It's Oyekomi and NEPA. In that case, as a matter of fact, the Supreme Court awarded, granted relief for professional fees. Found there that the bill of charges was sufficient in terms of particulars. And the Supreme Court was saying that you don't need to state everything you've done. And there's a decision of the UK. I'm not sure if Lord Denning was at the House of Lords then, or he had become Master of the Rolls at that point. But the case is in a solicitor. And Lord Denning was saying that, look, you don't need to state everything you've done, but you must give sufficient particulars to justify your fee. Now, in today's time, in today's reality, in terms of textbook, because again, earlier on I had said there is textbook, there is reality or practicality. Will a situation like, yes, of course, you should discuss the fee, give an idea to manage disputes ultimately, but I'm not sure that in all situations, 14 days will be sufficient to deal with everything concerning the issue of fees. But Indoma Egba versus First Bank brings us to another conversation. At what point, really, do you decide to sue your client? And what is the implication of that decision? In our climb, there are cultural issues. There are issues of, you consider reputation. What will the industry say about my practice? That the relationship has gone so sour that I've now taken my client, who I was meant to resolve his dispute or provide solutions for, I've now taken him to court. But there's also the flip side, that a client who has instructed you to help you prevent a loss is now putting you in a loss situation. So, you must balance it. But if you ask me, have I been in a situation where I've represented lawyers to recover fees? Yes, I have been. have I been in a situation where I've had to litigate against a client for recovery of fees? Yes, I have been. Good news is that even after I got judgment, that client came back to patronize me further. Thank you.
Thank you so much. The message from Bode is particularize your fee note. And now, part of what we did during the tour of duty as chair of the Remuneration Committee is to have conversations with lawyers, particularly lawyers who are of the view that by mere drafting of a conveyance agreement, you have earned the 10% provided under the remuneration order. And I said to them that that provision is for perfection of title, that until you register your client's interest, that you have not earned the 10%. That it's important that in your fee note to your client, you start from search up until registration of title so that the client understands why you're asking him or her to pay a certain percentage. And that's a conversation we'll keep having. But now that we are discussing resistance to fees, I'll go back to Mr. Ikechukwu, and I want to make a housekeeping rule, particularly for the... I know I've touched the wrong nerve. We'll get to that discussion, don't worry. Keep your gunpowders dry. Please, keep your gunpowders dry.
They're protesting.
Please keep your gunpowders dry. We are coming to questions and answers. So, the exact provision of the order, and that is perfection of title. I have received a petition, and now this is a true life story. We have received a petition as a committee that a particular lawyer undercharged. When we considered that petition, we found as a fact that the lawyer did not complete the task as envisaged under the remuneration order, and so he couldn't have undercharged. So my appeal is for us to go back to read the order and the prescription in the order. We can have this conversation as an ongoing conversation. But as at now, let us go back to Mr. Ekweme. Mr. Ikechukwu, and I want to make this clear. You know, when I came into this hall, I took a risk. Because these days it's a risk to call people by their first names. So I took a risk to call you guys by your first names. But you keep referring to me as Leonard Silk. Please, my name is Emeka. Let us make this as informal as possible. I'm not a chairman of a bank, and I would rather be addressed as Emeka. So, Ikechukwu, please, part of your work as an in-house counsel is to justify the legal fees you receive from external solicitors or counsel. Can you share with us your experience as to how difficult it is and how external counsel can help your work in justifying the fee notes they send to your organizations? Thank you.
Thank you, Emeka. And I will start by saying that first, fee management is a relationship management. That's bottom line, because you also want to work with the client going forward. It's not just a one-off affair. You really want to also maintain the client. So it speaks to the transparency of the fee, the proportionality of the fee, and also the proper basis for the charge. So when a general counsel receives an invoice from external counsel, the invoice most of the time doesn't just stop with the legal department. It goes to finance, it goes to treasury, it goes to payments audit, depending on the value of the invoice can actually go to leadership. So the question in my mind, it's not, and again, we are engaging a situation where there's a bit of unclarity as to what was agreed. Because if the fee engagement letter is clear. The amount on the engagement letter is the engagement letter. The question is, has the work been done? And of course, you need to make sure that you set up clear payment milestones in the engagement letter. But back to my point, what is going on in my mind is not just about an invoice or fee. The issue also is, does it deliver value? And those questions are going to be asked by the internal functions because it goes through a control process. The invoice from external counsel in a large organization is almost treated as a vendor invoice, a contractor invoice. It goes through the same check. So when there is a challenge that an invoice is high, I believe that recognizing that fee management is a relationship management, the client and the external counsel must have indeed a good professional conversation about that fee. And the approach from an external counsel point of view shouldn't be defensive. Oh, I spent 50 hours. That is 50 hours. Pay me 50 hours. To a large extent, identify, yes, we agreed X, B happened. This is the additional value. This is the additional risk we help to cover, we help to protect. That is why the fees are X. That way, you are able to find a balance. It could be that at the end of the day, clearly not all high fees are justified. Some could also be justified, but at least you're able to find a balance where there's an approval to pay that fee, or there's a quantum that both parties agree that, okay, it's 50 hours, I take out 10 or 20 hours, whatever it's 30, then I'll pay. But if you go into the shoes of an in-house counsel, for every instruction, there is a budget that underpins that instruction. So that budget has to be, that money has to be planned in the whole business plan and the cash kept. If the cost is now, especially for large briefs, if the cost starts moving beyond the amount budgeted, internally you are going into either a budget offset or an accommodation somewhere to find the extra money to pay. If it is justified, you can go to the controllers and explain, yes, it was 30 million, XYZ happened, these are the additional value. We are proposing that this fee of 50 million be paid. So my point is, it is a discussion that must be professional. And if there is a pushback, lawyers shouldn't get defensive, find a way of making sure that there's a value conversation in between. Even if where it fails to meet your expectations, which I have seen, it could also be that the accommodation will engender a future better relationship in terms of what other overall value the external can.
So going through that now, we'll go back to Aisha. Aisha, with all this, how can flexibility come in, especially for commercial engagements? Are there circumstances where a lawyer can charge above, and what are those circumstances? And are there also circumstances where a lawyer can go below? Can you, in practical experience, tell us how this can happen?
Thank you very much, Mr. Moderator. Let me begin by telling participants something, probably it may resonate with some of our colleagues here. So in trying to preach the remuneration order to colleagues, one of the challenges that I personally face is that colleagues will be like, Aisha, you cannot compare yourself and your practice with us. You cannot come and be telling us to look at a certain order and go by certain scale or fees. We have to just deal with what one of my colleagues even said, we down in the trenches. We cannot be going by any remuneration order that he has read the order that he doesn't feel comfortable using it. So from the protest earlier to all that we are discussing, yes, there's a category of colleagues that I may say would still be work in progress and we would still continue to try to let them see the value in using the order. It's still work in progress. I'm sure the chairman is still collating points and suggestions and recommendations on how to make it better. The simple answer to the question is yes, there is room for flexibility in charging. But of course, the flexibility must be consistent with the requirements of the order. Paragraph 8 provides that, yes, fees are as prescribed in the scales in the order, and there is no room for negotiation, but as permitted under the Act. There are requirements and there are provisions that allow us to either charge above and or below, but it must be within the requirement, within the provisions of the order. Paragraph 5 gives us as legal practitioners an important option that at the onset, before commencing work, we can opt or elect, as the order states, to use or go by the provisions of paragraph 2. And the provisions of paragraph 2 states the factors that we can use to scale as against to charge or price as against the provisions in relevant scale on a particular category of our services. So in practical terms, yes, we can charge above the minimum, but of course we have to comply with the provisions and state the factors clearly. For example, and it has been mentioned earlier, where the scale provides regarding a particular service an amount, say for example, 1 million naira, but then you, from the instructions that you've been given, from the brief that you have, you know that it is extraordinarily complex, the matter extraordinarily complex, requiring extensive review of documents. And you know, we have clients that would give you instruction today and tell you that before close of business tomorrow, I want this agreement either signed or the final draft considered. So where you have a short turnaround time and value that is attached to the matter by the client, it gives the lawyer, it gives us room or legitimate reason to charge higher. But of course, we must state clearly why we are charging higher, and we must communicate that, like was stated earlier, with the client and agree with the client. Because at the onset, before you commence work, you need to ensure that the client understands exactly what you are charging for and why you are charging for that service. Now, let's look at what the order says about charging below the prescribed minimum, which is very important, which is where we need to be careful, especially where implementation intensifies on this order. Paragraph 10 of the order provides that where a lawyer intends to charge below the minimum prescribed, the lawyer must apply to the remuneration committee and must disclose the circumstances that are necessitating the intention to charge lower than the minimum prescribed. This is very important. And please read the order to see the procedure from application to either approval or rejection of the approval. So from the requirements of the order, you can see that there is room for flexibility. And the order also recognizes pro bono work, legal aid work, and also recognizes that sometimes we are in a position that we would have to render our services for free because we may have some relationship with our clients. So, but all that must be done within the provisions, within the requirements of the order. So, the important point to have in mind is that when we negotiate our fees, or when we price our services, especially the private practitioners, we have to have in mind, and I think I mentioned this earlier, and well, I would emphasize it again, that what you are negotiating is not just an amount. You are not haggling. You are placing a value on the service that you are rendering. You are placing a value on your experience. You are placing a value on your time. So you have to understand that, yes, the order provides for certain minimum and also provides for what and the factors that you must consider when you are pricing. The important thing is not whether you are pricing above or below. It is that, you know, at these times we have sophisticated clients. Clients, and especially from Mr. Ikechukwu, we have an understanding of what the client's expectation is. They expect transparency. They expect professionalism. They expect consistency. So we have to have that in mind. As the client is sophisticated, we have to also up our game. We have to have in mind that it is not just by presenting a figure, but by making sure that the client understands the value you are presenting. So I may sound like I'm pro-charging higher, which of course I'm sure our colleagues would be more interested in. And also to emphasize that the order, even though it's giving us flexibility, it's not giving us a license to charge lower just because, and that is what the debate that has always been ongoing, that the client says, well, I know another lawyer that can charge less. So know your value, know your worth. Thank you.
Thank you very much. I see that the ladies are more pro high charges. So, Chinyere, flowing from Aisha's presentation, what billing models or systems do you propose? From your practice, what billing models do you adopt? And how have they helped your practice?
Thank you for that question, Leonard Silk. On a lighter note, can I call you Tony? I can't call you Emeka.
Please call me Emeka.
I'm sorry. Okay. Jokes apart. So I really think that the question shouldn't be whether it's billable hours versus price, value pricing. We can't put ourselves into a box. That's the only things to consider when, billing our clients is billable hours or value. I think that the law has evolved into such a way that there are multiple, in fact, I have like 6 or 7 different pricing methods that we can use, and the truth is somewhere in between there, somewhere. Because clients are different, and some clients prefer different pricing methods. I guess what I'm saying is you have to know your client. You have to know what works for which client. In some situations, a client may prefer billable hours that we've all talked about, but in other cases, the client, doesn't mind a fixed fee. The truth of the matter is there's no one size fits all. The size of your practice matters. How able are you to absorb the cost across the entire value chain? If you're a large practice, maybe you'll be better able to absorb the cost. But if you're a small practice, the situation may be totally different. And so I love the fact that the Remuneration Act does make provision for flexibility bill.
It's good for complex litigation, investigations, negotiations, even involving regulatory matters. That's where you can come up with your hourly billing. And of course, we all know that in legal practice, the billing rate for, say, an associate or a trainee associate is different for a senior associate, is different for a managing associate, is different for a partner, and of course, is different for a SAN. So depending, and you know in your heart that the client will not agree to pay. You know, but that's just the basis. And certain types of opinions, you can't really do billable hours. Now, my experience has been that clients really like billable hours because, fixed fees or flat fees, because it gives them certainty. Like he said, it's in the budget, they know how much it's going to cost, it's not rocket science, they just know what it will cost. But we must also, again, define the scope carefully, because in some cases, what may seem to you, you might think is profitable, but at the end of the day, the fixed fee is not profitable. Now, let's talk about retainers. Retainers is number 3. Retainers work very well. Number 4, capped fees. This is really hourly billing, but with a ceiling beyond which you cannot go, and you must justify it. So it can work well where the client really does want some sort of certainty, but the lawyer, you can't really predict how it will go or how much work will be required. So in order to give yourself a little bit of leeway and also make the client happy, you cap the fees at a certain level beyond which you can't bill more than those hours. But always, I say always leave room for negotiation if something fundamentally changes. Number 5 is milestone. Milestone or stage-based billing. Milestone or stage-based. This may have worked well in the case that Leonard Silk Bode talked about, if they had put a milestone billing so that you don't need to wait until the end of the transaction or the end of the litigation before you earn any fees. Because as lawyers, we cannot guarantee to our clients the out of the situation. But at the end of the day, let's be flexible. I believe that law practice has evolved, is still evolving, and so many different, there's not one size fits all. It's not value-based or billable-based. It can be a combination of different ones, and at the end of the day, I keep saying it, law is a business. We have to be profitable. The way the legal services industry is evolving has to have all of us going to business school. We all have to go to business school. We need to do accounting for non-accountants as training so that we can learn these principles and not only focus on the doctrine of law, but also on the business of law. Sorry.
Thank you very much. Thank you so much. The last intervention, Mr. Isdo. Isdo, can you mentioned the systems that will help us collect more fees. Now, how do we know what are the flag points to understand when these systems are not existing and when they are installed? How do we know in concrete terms that they've added value to our practice?
Okay, thank you very much.
2 minutes, please. 2 minutes.
I'll be very brief. I'll be very brief. Okay, to know whether these systems are working to help us not to lose money, I would recommend 3 steps. The first is diagnosis. The second is what I would say configuration. And then the last is the rollout and deliverables. So for the diagnosis, what I mean by that is we all have our various practices. We need to go back and determine the current state of play. What is actually going on between intake to cash? What is that process? What am I losing? Right? If you don't know the current state of play in your practice, you won't know whether anything is working. So even if you go and deploy a system, you may not even know the value. So in that diagnosis, you need to list out the revenue leaks. Where am I losing money? Is it in collection? For instance, some terms of agreement to say final payment upon judgment. What if you lose the case? Do you think the client will pay you after losing the case? And your terms of engagement says final payment to be made upon judgment. You don't do that. Please, I'm advising everybody, put at least upon final written address. So that may be where you're losing money. So you list out these revenue leaks. You ask yourself, if someone walks into the firm and says, can I have a matter on this client? Are you able to produce all that? So these are some of the questions that you have to ask yourself. For the configuration, you go beyond, okay, having determined the revenue leaks, how do you make it work? So that what do you need to put in place? Do you need a standard template for fee arrangement? Do you need a standard template for engagement? If it's hourly rate, are you now going to deploy maybe daily recording of the time? Or, of course, daily is the best, because if you leave it for the week or the month, you may never get to it. So these are the steps you can do for the rollout.
And the last person, please, can you come forward? Can the 5 of you come forward? I'm so sorry we may not be able to take more questions. Can the 5 of you please come forward, ask your questions, and then the panelists will take your questions.
Thank you very much, Mr. Moderator, and thank you all speakers. My question goes to, I believe, the last speaker, Mr. Isidore Uzwo. I want to find out, in this issue of agreeing fees with clients, there are 2 things. One, many times you deal with large corporates, and when they are instructing you, they give you their fees. In fact, last week, I've had to decline instructions because the fees were insulting in the extreme. So what do we do to make sure that in-house firms begin to comply with this remuneration order? Secondly, as to the issue about stating the fees, the milestones for payment of fees, when they're instructing you in litigation, they will stage the fees and tell you the last fees will be paid upon judgment. Are you now saying that we should tell them that we should be paid when we are filing the last process or the last written address? And how can that work out in practice? I'd like your perspective on that. Thank you.
My name is His Greatness Agadaego. I'm from Asababa, the premier bar of Africa. I'm directing my question to Mr. Bode Olanipeku. And because you have taken a client to court, and me, I'm also planning after this conference to take 2 of my clients to court as well. So I need your experience. If in the contract of engagement you had with your client, you did not specifically state when the balance fees should be paid, but by consensus added them, it ought to be paid within a reasonable time. And the client pays you the value which has been devalued 2 years later, and you are taking him to court when no written agreement states that. Mr. Bode Olanipeku, what is His Greatness Agadago, what is my chances of success in this voyage?
Thank you, sir. Dr. Maxwell Price is my name. So please, just mention your name, identify the person, ask your question. No comments, please.
Yes, sir. My question goes to you, sir.
Thank you.
Yes, sir. With respect to this conflict between the order and this Federal Competition and the Consumer Protection Act, Because there is one matter on ground now where somebody who claims that he's a pocket lawyer, not even a lawyer, so to say, saying that my order that NBA just produced to favor themselves, that is in conflict with the Federal Competition Consumer Protection Act. He specifically mentioned Section 59, that even the exemption that we're supposed to rely on did not even favor us. So we are trying to sort it out. So my question now is that, have this particular issue been resolved? Because considering that if this order is in conflict with the act as they are presenting it, of course, you know, we all know the position of the law. How do we get this thing resolved? Because it is a very fundamental issue that needs to be resolved. Thank you, sir.
My name is Deji Adeyanju. My question is to the Leonard Sik and chairman of the remuneration committee.
The next legal practitioner is ready to subcharge your client if you want to comply with the remuneration order. Now, are you going to just allow your client to leave you and go to the next legal practitioner because you want to comply with the remuneration order, fully being aware of the fact that this is a legal market and you also need money to fund some of the needs, your personal need and the needs in the office? Thank you.
Good afternoon, distinguished panelists and delegates at this conference. My name is Tony Atambi. I'm of the Lagos branch. My question is, how do you deal with the sometimes murky waters of having to have clients who are friends or family members, you know, on the one hand, and returning clients? Now, these are two interesting sets of people. Friends and family members, you know, they feel a sense of entitlement. You know, they are friends, you drink together and all of that, and they need these services. And sometimes, you know, there is a bit of a fine line, you know, that's on the one hand. And then on the other hand, returning clients who also feel a sense of entitlement. You've done work for them before, they've paid you handsomely, and then, you know, somehow they want to sort of, off the back of that relationship, continue to engage you in ways that are not formal, you know, to still get services regardless. So how do we deal with these two special sets of people? Thank you.
Thank you, Mr. Moderator and panelists. Akajugo, this question is for you, and then maybe any other person can answer. The remuneration order provides essentially for minimum fees charged to be charged by legal practitioners. And so I want to assume also, or confirm to me, sir, that the 10% for conveyancing under the order is also a minimum. So if a client agrees to pay 10% for just the drafting of the paper, that a lawyer is not in breach of the remuneration order. And then secondly, sir, I've always had a challenge as to how to assign value to a conveyancing document that is unregistered. Okay? And so it's kind of difficult to say that you are charging someone 10%, maybe of 10 billion naira or 10 million naira for just drafting without perfection, without registration. And so the question is, what value is a lawyer bringing in when you just merely drafting a document? That's the question, sir.
Thank you very much. I note that Bode and Isdo are expected to answer some of the questions. So we'll start with Bode. After Bode, Isdo will take. Bode, you have 2 minutes, please. Isdo, you take 2 minutes. The other panelists will take 1 minute each to make closing statements. after which I will attempt to answer some of the questions posed to me in closing. Thank you. Bode, please.
Thank you very much, Leonard Silk. And I'll go straight to the question from the colleague from Asaba branch, I think, Mr. Greatness. Now, your best case scenario really is to stick with what has been agreed, even if it means you would cut some losses. So if I were to proceed in your situation, I will sue for what has been agreed and know that at the worst, I will get what has been agreed. Now, is there scope for a review of fees? I think there might be scope for a review of fees. Again, depending on if the instructions came before or after the remuneration order, because that might be a challenge. Again, sir, you know, the import of the remuneration order, will it be an objection to the competence? If you don't comply with the remuneration order, will it be an objection to the, is then reasonable that your entitlement to fees might increase? If scope of work has increased, I think that you can also review your fees, but at least do what is basic. The Adeyanju's question, very, very, very important, particularly this issue of source of a client's funds. And I think there's a court of appeal decision on that in a decision relating to Chief Michael Zekome, where the court of appeal said that, you know, in a manner of speaking, that he had not crossed the line of money laundering. So we must really, and it's an issue that could take us a whole day to debate, as to drawing the line between access to justice and money laundering or active participation in money laundering. Of course, as a dispute resolution lawyer, I am all for access to justice. And I believe that anybody going into the justice system as a defendant or as a litigant in whatever way should not be stymied or inhibited from accessing the best legal services that it can afford. Now, where does the responsibility fall on a lawyer? A level 5 civil servant instructs me, for instance, hypothetically, and I know that your salary is 10 million naira per annum. I now brief you, I now bill you 200 million naira, and I pay you, and you pay me. I think that I must have crossed the threshold of any reasonable defense of lack of knowledge as to the inappropriateness of the source of income. Now, if I feel that the value of service I'm bringing will be priced at over what I see as your source of income, I could ask you, this is what I'm worth, or this is what I feel my services are worth. How do you intend to pay? How do you intend to meet these obligations? If you explain to me satisfactorily in a manner that I can face the public and my regulators tomorrow, if they come to ask me questions, then I think I'm good to go. Because again, the offense here is reasonable knowledge. So at what point have I crossed that threshold of reasonable knowledge? But again, for me, I am all out for access to justice. And you know what? If we deny defendants access to justice, particularly in criminal litigation, it is the taxes that me and you pay that the government will use to hire legal services statutorily for them. Thank you.
Thank you very much. Isidore, please, can you intervene? 2 minutes, please. 2 minutes.
Thank you very much. I will try and stick to 2 minutes. The first question, they are together. They were expected to file motion for stay, all that, and then pay you. So there is that difference. I will not tell you here to reject the fees. What I will say is that you have to negotiate. Always make that attempt at negotiation. Don't say, if I say this, they will take away the work. Just make an attempt. Draw their attention to the remuneration order and see what happens. If you don't make that attempt, you may never get anywhere. The person that talked about losing fees to other lawyers is a real concern. What happened to me last week or thereabouts? It's clear. So I won't give that an instance. But there is a remuneration, the part of the remuneration order, paragraph 11 of that order says, you can report, if anybody is found violating this order, report to the remuneration committee. But that provision needs to be operationalized. I expect the remuneration committee to have a portal for such reports. In fact, there are 3 reports for the remuneration committee. One is, if you want to do pro bono, you are expected to tell the remuneration committee you want to do pro bono. If you want to pay charge less, you are expected to tell the remuneration committee you want to charge less. Within 7 days, if they don't approve, you go ahead and charge less. And if you see a lawyer undercutting, you have to report to them. We are dealing with lawyers spread all over Nigeria. How do you manage it? Do you expect lawyers to write hard copy letters and use FedEx to send it to Abuja? But it will not work. So I will be advocating for those provisions to be operationalized, that after this session, we can have a portal for reporting lawyers that are undercutting, for applications to charge less, and for reporting pro bono work or family relationship work. I will end by just 30 seconds response to this written instruction and losing your brief. And whether it's insensitive within that 14 days. You can write the terms of engagement, use the provisions of the remuneration order and say, at this stage, fees have not been fully agreed. There is no provision that says the client must sign. You can put a clause saying, by continuing to instruct us, you agree to these terms. You send it. That case, you take away the issue of, you have been insensitive because you've said that fees have not been agreed, pending when the issues are resolved. That way, you have complied with the order. And another way to do it is to tell the client, if I don't do this, they will derobe me. Look at order 7, paragraph 7. Please, can we have this conversation? And as Mr. Kwame said, it is professional. And I think we should stand to that. Thank you very much. Thank you.
Thank you very much. Aisha, 1 minute, please. Not more than 1 minute.
Thank you.
Closing words.
The remuneration order, to me, is a positive step towards recognizing that the practice of law as a profession is also a business. And the order is providing a foundation upon which we as lawyers must develop the commercial discipline to build it into profitable, sustainable practices. Thank you.
Thank you very much. Yes, please.
Okay, thank you. In the business of fees, I want to leave you with a few nuggets. You must understand revenue. You must understand profitability. Your profitability sits in your cost. You can actually have 10 million. You're not running efficiently. You have the revenue coming, and then there's no profitability. Without profitability, you struggle with growth. Remember, your profitability sits in your cost. How efficient, how are you deploying technology? Very key. But in quick summary, I believe that if we price efficiently, if we price clearly, if we have that professional engagement with clients.
Do not pay us or a returning client who has seen you finish and doesn't want to pay. That's really what it is. I think that a distinction has to be made. A family member is not a client. So don't even go calling them a client. If you know you're not going to provide the service pro bono, then don't do it. Don't engage with the person. The same goes for a client who doesn't want to pay you because you become familiar with them. Send them to a younger client within your office. Do not be forward-facing with them, or another partner. So you are not the one dealing directly with them. Let them tell that person they're not going to pay. It becomes a harder conversation for them. So send someone else to be a lead. My closing is that not every client is a good client. We have to get to the place where we learn to drop some clients along the way.
Thank you so very much. First, let me assure you, Isidore, that the Remuneration Committee has a designated email address for reports. So we don't need you to send letters or FedEx from any part of the country. Upon a click of a button, we'll receive your report, we'll receive your applications, and we'll deal with it. And Chinyere, unfortunately, I charge relations. In my firm, relatives pay. Yes, they do. They may pay different scale, but they pay. Firms thrive when relations pay. So please, where you can, where your relatives can afford to pay, let them pay. So Maxwell, first, the remuneration order was not introduced by the Nigerian Bar Association, as you said. It was signed into law by the Attorney General of the Federation in his capacity as chairman of the General Council of the Bar. So that is for knowledge. And then if you read the order, you will see that in as much as the Competition Act pertains to protect consumers of services, this order protects our prospective clients. So I do not see any conflict in what the order provides for and the Federal Competition Act. But I'm happy that the matter is in court, like you said. And if you don't mind, if you can share the details of the litigation, I would like on behalf of the NBA to file an amicus brief to explain some of these things better. Because the order, in my view, protects clients in as much as it provides for lawyers' welfare. Yes, conveyancing. There is a reason why in commercial agreements, no matter the volume of money, the fees do not differ as much as it is with conveyancing. The order talks about perfection of title. And even me will resist paying you 10% if you just print out a document from your system, edit it, and give me to sign. I will resist it. And that is why we face the pushback from clients. We talked here about explaining the basis of our fees to our clients. If a client believes that you're just going to print out deed of assignment, power of attorney, sale agreement from your system, and earn 10% of 100 million naira, the average client will resist it. So I appeal to us. And there are ways around this, like I said. In my office, for example, what we do is to give you a fee note. Due diligence will assign a value to it. We can assign more value to preparation of documents and less value if you think you may not want to register. We can assign less value to registration of title. So when we have earned 8% and 2% is left for registration, if you don't want to register, you take your document back. But what it does for us is that you cannot come back to say that we'll charge you for perfection of title and we did not perfect title. So we must protect ourselves. When we say that the 10% is for perfection of title, I am on your side. We are on your side. We want to make money, but we also want to make money in an ethical way, so that when we rely on the remuneration order to charge our clients, we should comply with that same order. And bear in mind, too, that the 10% is a mere minimum. So when the value of the property is less than, for instance, 1 million naira, why will you charge 10%? And resistance to payment of fees. And that is the message we have for you today. So on your behalf, let me thank the panelists. As at yesterday when I spoke with Bode, he was in London. He took the evening flight from London back to Nigeria this morning and made it to this place. So Bode, thank you very much for your sacrifice to the bar. Thank you for your being here present. I know the cost, the personal cost to you, and I know that by tomorrow or next, he'll be going back to London. Thank you very much. Chinyere, we can't thank you enough. You've been sacrificial to bar activism. Thank you so much. We enjoyed your perspectives on these issues, and I'm sure we have learned quite a bit from you. Ikechukwu, again, today we are hearing from an in-house counsel. We know their expectations from us, and perhaps for those of us who work for corporations, we can now begin to tailor our fees and our engagements in this session. This session deals with the trending issues affecting us all as lawyers. And through you, we thank the council, and we appreciate the opportunity to be here. Distinguished colleagues, I take my bow. Thank you, and have a great day.
Thank you, everyone, and I hope you all enjoy the session. I would like to call, first of all, I would like everyone to give a round of applause, a clap ovation to the youngest lady of the bar, the most beautiful soul I've ever met. It's a privilege to have her in our midst. She's no other person than our dear mommy, Mama Irat Balogu OON. It's a great pleasure to always see you every year in every gathering. And I pray that the Lord Almighty will continue to give you strength to move every day to attend all programs. Thank you very much, my Shema. And to this end of the session, I would like to call on the chairman of the section on legal practice, Mrs. Folashade Ali, SAN, to come and present the gifts. Alongside Mr. Frank Briggs, we would like you to come off stage, please.
Oh. Oh, that's his challenge.
Good afternoon, everyone. I'm quite sure you will agree with me that we've had a very engaging session. We don't have much time, so without much ado, this is for who? Okay. I'll start with the moderator. Please come with me. Thank you very much for moderating a very engaging session. Thank you.
Thank you so much.
Thank you. And to the Leonard Silk, Mr. Bode, Olanipẹ, Continuing Advocates of Nigeria, thank you very much. We've enjoyed everything, especially I learned a lot about the cases. Chinyere Korocha, my mentor, my chairman, Women's Forum, thank you very much. Thank you. And to the only in-house counsel in the house, Mr. Ikechukwu Ikweme, thank you very much for your perspective. We really appreciate you. Thank you. Aisha, well done. Thank you. Thank you very much. Thank you. Thank you. Isidore, we're grateful. Oh, I need to take. Thank you. We're running late, so the next session is waiting for us. And just a group picture with everyone.
Check.
Thank you very much. Good afternoon, everyone. Please, can we resume our seats, please? Please help us. Our session is already started. Please, could you resume your seats? So we're starting the YLF session, and we're hoping that this room will be filled with young lawyers of the Nigerian Bar Association. The speakers are well set, and we are ready to learn from them. Thank you very much. Thank you so much for helping us. We're really, really behind time. Please help us resume your seats, please. Thank you. Thank you so much. Thank you so much. Please, if you're at the stage, please help us resume your seats. Our time is so fast spent. So we're starting the YLF session. Good afternoon, everyone. Good afternoon, distinguished Leonard Silks, distinguished judges, distinguished seniors, colleagues. This moment is for the Young Lawyers Forum of the MBA, and we have a very limited time. We want to thank you for being in our midst. Please, can we go? Do we have a one house? Can we have a one house, please? Please help us. Help us. Thank you. Thank you very much. So this moment is for the Young Lawyers Forum of the MBA, and we expect that if you are in this hall now, regardless of your age at the bar, would ascribe the Young Lawyers title to you. In a few moments, we are going to be listening to some of our colleagues and seniors who will be sharing various experiences on the theme Position, Build, and Thrive. Position, Build, and Thrive. So we expect that we are able to make progress with you in the house, and we expect that you would also help us make good use of our time. So without wasting time, I see that it's a busy hall, and we may have to make progress regardless. Without wasting time, I want to I'll start with myself. My name is Oluchukwu Nwako, and I will be moderating this session. And also, I'll be joined by another moderator of the panel session much later. So to move forward, we would like to recognize, in no particular order, the President. Sorry. Please, we have a missing item, a missing purse. It's a female purse. Please, if you have checked and your purse is missing, please come to the stage right about now to pick it up. If you have misplaced your purse, it's a female purse, a black purse, please, I'm sure it belongs to someone who just left here or who was around here. Please check if you can't find your black purse. It's not stolen, it's misplaced, and we have it here. So just make your way to the stage and you pick it up. All right. Thank you very much. Once again, I welcome all the young lawyers. I can see a lot of young lawyers trooping in. And like I said earlier, if you are here by now, no matter your age at the bar, we'll be regarding you a young lawyer. And we are happy to also have seniors join us in this session, because it's a learning experience and we'll do all that together. So I recognize the president of the Nigerian Bar Association, though in absentia, Mazi Afam Osigwe, SAN, as well as all the national executive officers and the NEC. We also recognize, please permit us, because of time, we'll skip a couple of protocols. We are trying to manage time for which we are constrained. Recognize all other officials. Recognize the president-elect, Mrs. Badejo Kunsaya, SAN. Also in absentia, they will be joining us very shortly. We also recognize the chairman of the Young Lawyers Forum, who is also present here, the governing council of the Young Lawyers Forum, and all the ESCOs. It's our session, so we are happy to have you around. All the YLF chairmen and ESCOs and different branches of the NBA, we see you and we recognize you. Moving forward, I'll be going straight to introducing the panel so that we save time. I thank you for your cooperation so far, and I assure you that in a very short time, we'll be out of here. All right. So we'll be having a panel of 6. As you can see on the screen, we'll be having a panel of 6 and 1 moderator. It's going to be a rich session. The theme is position, build, and thrive. And all the sessions will be around that. Perhaps you're looking forward to getting more direction on your career path. This is a session that you would really want to participate. Or you're looking forward to checking to see whether you're still on the right path. This is also a session for you. Right? So we hope to have a very good moment here. All right. So in no particular order, I want to welcome to the stage here Mrs. Emokiniovo Dafe Abedeye. Please, can we put a round of applause to her as she makes it to the stage? Please help me just appreciate such a very wonderful woman. Thank you. Can we do it better for her, please? Can we, please? Thank you. Before she sues me, you're welcome. You're welcome, please. I'm so sorry if I didn't pronounce your name so well. Okay, she said I did well. So, yes, Mrs. Dafe Abedeye is a practitioner par excellence. She is a chartered arbitrator and a qualified solicitor. The UK, a CEDR accredited mediator. You're welcome once again. Moving forward, I would move to the other agenda now and then come back to another one. I want to welcome to the panel Mr. Desmond T. Oriseweze, who is the managing partner of Vansford Solicitors and Advocates. Please help me. You will be helping me today a lot. Please help me welcome Mr. Desmond. You're welcome. You're welcome. Please resume your seat. Commonly known as DTO. Please permit me to skip the profiles. We are really constrained by time. I'll move to the other agenda now. I want to welcome to the panel Ms. Onyinye K. Omenora. Please let's celebrate Ms. Onyinye as she makes it to the stage. Ms. Onyinye is the founder and the team lead of Laws and Aid. Laws and Aid is an initiative that advances disability inclusion across Africa. So we're happy to have you. Ms. Onyinye, please. You're welcome to the panel. I want to also welcome another distinguished senior colleague, Mr. Abila Dane Mobawe Silvanus. Please let's applaud him as he makes it to the stage. Please help me. Don't get tired of helping me to celebrate these amazing people. You're welcome to the panel, Mr. Abila. We're happy to have you. Mr. Abila is fondly called DOS Abila. He's a chartered arbitrator, conciliator, mediator, and a consultant in many areas of law. We're happy to have you. I want to also welcome Mr. Omar Farouk Hussein. Mr. Omar Farouk Hussein, we're happy to have you. Please, let's applaud him. I've pleaded with you not to get tired of clapping for these ones today. And you're doing so well so far. Thank you. Mr. Omar, you're welcome to the panel. You're welcome. Okay. And the last person, but not the least, definitely not the least, is Mr. Mohammed Adam, Esquire. Mr. Mohammed Adam. Such an elegant gentleman. Mr. Mohammed has just concluded his Masters of Law. You're welcome, Mr. Mohammed. We're happy to have you.
Are you sure they're on?
Wow, what a panel.
Are you sure they're on?
Looks like it's going to be a very significant session. Okay, we have a lot today, and we have a couple of things that will be done after this session that are very significant to the YLF. So if you're a member of the forum, you may want to really stay to the end. There's something will be unveiled today after their session for the Young Lawyers Forum. May I please welcome the moderator of the panel session, Mr. Ikechukwu Promise Obialo. Please let's welcome Mr. Promise. Promise works with Wigwe and Partners. You're so welcome. Welcome. Please resume your seats. Okay. So remember I told you I'll be doing this with him. So time has come for me to hand over the microphone to him. But before I do that, we are going to have a presentation by one of the panelists. And right after the presentation or her session, would go straight into the panel questions. Please may I invite once again Mrs. Moki Nilfo for her session. Please let's applaud her. Welcome.
Thank you so much. Good afternoon, learned seniors and learned colleagues. Let me first start by thanking the organizers of the Annual General Conference for inviting me to speak and to set the stage for our topic today, which is Position, Build, Thrive. I call it Building a Sustainable Legal Career. So, it's very evident that the Nigerian legal profession today is changing very rapidly. Of course, in comparison to previous years when some of us started, things are not as predictable as they used to be. We have AI, we talk about that a lot. We have technology, which means that basically some of our clients might not think they need us. They can go ahead and prompt AI to draft contracts in a matter of minutes, right? And as well, we have integration, global integration. If you look at the African Continental Free Trade Agreement, there's supposed to be greater integration across 54 legal jurisprudence. And so this dynamics really makes the legal market more competitive and I would say more interesting. So let us not be wary that this means that there will be no job for us. Now let's look at some of the developments that have happened in in the last few years. The Nigerian Data Protection Commission has moved into what it described as full enforcement mode. It has concluded 240 investigations. It has issued compliance notices to nearly 650 tertiary institutions and 1,368 companies in a single exercise. And this could potentially lead to fines of 10 million naira or 2% of annual gross turnover. We also have had the Investment and Securities Act of 2025, which has formally brought digital assets within the securities regulatory framework. Of course, we know that in July of this year, the President signed an executive order establishing the Virtual Asset Council to coordinate the activities of CBN, SEC, and the relevant tax authority. For those of us in the ADR space, we all know about the Arbitration and Mediation Act of 2023, which is supposed to strengthen Nigeria's position as a potential continental hub for dispute resolution, and it has introduced third-party funding so that the laws of maintenance and champerty no longer apply when it comes to arbitration. Now, why did I think that it's important to list this out? It's important to list this out because it shows that there are new areas of law, and there is potential, a lot of potential for the young lawyer. So the topic that we have today, position, build, thrive, should not just be viewed as some motivational slogan, but we really need to imbibe it to understand that, yes, our market is more competitive, it is more technologically driven, and it's more global, but we can thrive even in that market, okay? So I'm going to take each, I don't know if you can get my slides up, but even if you can't, I will start the topic. I'm going to take each one, position, build, thrive. Now, positioning, that is really the starting point of a sustainable legal career. The question I want all of us to ask ourselves, if this legal profession as we know it today disappeared and reassembled itself, would there be a seat with your name on it? That is the positioning. So positioning is not about being loud. It's about being locatable. It's about being found by the right person for the right reason and at the right time. So we talked a lot about, even in the last session, we talked about value, but it must be value over activity. And sometimes lawyers confuse being busy with being valuable. Those are two separate things. So yes, we have to attend courts. You have to draft pleadings. You might have to run due diligence, but you still need to be professionally visible. And I must commend some of the young lawyers in the room. I see, what a lot of them are doing online. It is about staying relevant and staying visible. So your publicity must be a deliberate decision. You can't just be public for the sake of being public. And you must be public, you must do your publicity in a way that it is for the right things. Now, we always hear this conversation about whether being a generalist or finding a niche. While I will not, advise any young lawyer to say, oh, I'm only taking X kind of work, it is still important to find a niche, something that makes you recognizable, an area that you can give a recognizable value to the society. And as I said, it doesn't mean that if a land matter falls on your table or any other dispute falls on your table, you say, no, please, I'm a tech lawyer, I'm a blockchain lawyer. No, it just means that you have an area of law that if a senior or if your colleague has a challenge, they say, okay, go to Mr. X or go to Miss X. I'll give you an example. A junior colleague of mine, he's about 4 or 5 years, post-call now. He started at an organization and a client had a tax issue. Now, this was before the tax laws came into force last year. And they asked him to do research on that area. And he did the work so well that now in his law firm, he is known as the go-to tax expert. Just at, he was barely just out of the call to bar, and he's already known as a tax expert. Yes, that fell into his lap, but he has chosen to harness that niche. And of course, now that we know with the new tax laws, he's very, very valuable in that market. So please choose a niche, think about it. It must be something that you have a genuine interest. It might be like my younger colleague who it fell into his lap, or it might be something that you have researched, you have done your projection and seen in the next 5 years, there are going to be disputes in this area. I'll give you another area of law people are not looking at. ESG, economic, social, governmental policies. If you look at the Climate Change Act, many of those policies are going to become mandatory. Is anybody looking at that and saying, oh, I can be the lawyer of the future. I can be the lawyer that does this for clients and, you create value. So as I said, positioning, being visible. Visibility is not the same as credibility. Remember I said, be visible for the right thing. Don't just use AI to write your article and produce it on LinkedIn or any other social media platform. You will easily be found out. When the client contacts you, you will not have the requisite knowledge to deliver value, and that can be very, very damning for your career. So remember, build, have your positioning, decide what you want to do, and then invest time, invest energy. If you need to go to a professional body, whatever the professional body is for any area of law, please seek that knowledge. It is very important. Now let's move to the second stage, build. So we've done positioning, which tells us the markets you want to look out for. Now building, what do you build on? Remember I said competence. Competence is the bedrock. You cannot permanently compensate for a lack of competence. So while it is good to post online, if you don't have the competence, you'll be found out very quickly. So please build competence. Then the second thing, your relationship. Leonard Silk from my law firm of blessed memory used to say that the law is a contact sport. Who do you know? Who are your mentors? Who are your sponsors? Who can speak for you in rooms where you cannot be? And I'll give you an example. When I first started up in arbitration, I think about 2016, I really, I was coming to a space. I just done my associate membership. What did I do? I ensured that I served. Every time there was a conference, I put myself out to serve. At a point, we had the Young Members Conference of the CR, and unfortunately, somebody that was supposed to do the moot arbitral proceedings dropped out. And somebody called me and said, Kinyobo, can you do this for us? And I immediately jumped. The day before, I immediately jumped at it and said, yes. By delivering that, eventually they invited me again to be a speaker 3 years after. And from that speaking position, I was giving my first arbitration brief. So that's how you build relationship. Not when they call you to serve, you are looking for, will I be compensated? Will they pay my transport? The truth about it is that there must be a level of volunteering. You must volunteer in this profession because then you can build mentors, you can build contacts, and those are the contacts that will remember you and will give you jobs in the future. Then also you must have a client-centric mindset. So your client does not care about the law. They don't care what the CBN Act says. They don't care what the guidelines says. They don't care what the regulation says. What they care about is that I want to do X. I want to bring this product to market. How can I do it? So when you are giving advice, give advice with that understanding of the commercial reality of your client. Make it commercially relevant and be creative. Think of ways that it is possible to do what you want to do. Yes, the law, sometimes there's gray areas in the law. So if the law does not strictly prohibit it, then there's a leeway for you to advise your client while obviously giving the clauses that, of course, we have not tried this. But then your client will see you as a lawyer that is a commercially sensitive lawyer, okay? Now that we've talked about positioning and building, we move on to the third stage, which is thriving. How do you thrive? How do you keep being relevant as trends change? I mentioned AI before. Use AI. I use AI, but use it as a tool. Don't use it in a way to abdicate your own professional responsibility. I'll give you an example. An award was set aside, an arbitral award. Why? Because the arbitral tribunal abdicated his responsibility. What did they do? They simply uploaded processes on AI, and AI, did its thing and produced what would be an award. Now, there are so many ethical issues with that. Number one, confidentiality. You have breached the confidentiality of the process. And as lawyers, we know that confidentiality is very, very important to our process. So even if you must use AI in certain ways, make sure you anonymize your information. Don't allow it to be easily linked to your client. Don't upload full documents in bulk just because you want to be lazy. So you will not thrive that way. also look at opportunities. I mentioned the African Continental Free Trade Agreement. There is a protocol on trade in services, and there is a move to liberalize legal services. Of course, we know that's not possible for now because we have qualification issues. You must qualify in each jurisprudence. But still think about it. Let me give you another example. I happened to be called to do a debate again in Siab, and my debate partner was a Kenyan. So, of course, we entered a WhatsApp group and we're communicating, and then we had the debate, and of course, Nigeria won. But after that debate, we stayed in touch. We saw each other at conferences. And late last year, she called me. She said she has a client, a Kenyan client, who has a Nigerian law-related issue. And she referred that client to me. So you can see that even though I cannot practice in Kenya, sometimes they will have clients that have Nigerian issues. And even sometimes I may have clients that have African law-related issues. So this is how you build. This is how you thrive. And then, very importantly, we need to be adaptable and to be resilient. This profession, you need to think of it as a long-term game. It is not for the shortcut. It's not for 2 years. It's not for 5 years. Even as I stand here, I cannot tell you that it only takes one brief to change your life forever. I've been told that for as long as I can remember, that it only takes one brief. So if you continue doing the work and doing the right thing, don't be known as a lawyer that takes shortcuts. You will not thrive very long. Yes, you might make some money by the wayside, but you will not thrive for very long if your integrity is in question. So finally, let me go to the last slide because I thought it was important to give practical ways in which you can position, build, and thrive. Please, can we go to the last slide that has the table? So I've divided it up to 30 days, 6 months, and 12 months. Please, can we have the last slide so that they can see it pictorially? So I think that this is some of the things we can do. And even as I wrote this down myself, I'm also implementing some of these things. So in the next 30 days, what are some of the things you can do? Audit your last 12 months of work and look for recurring patterns. And then shortlist 1 or 2 potential niche areas of practice, things that you can delve into deeper to gain knowledge and to gain experience. Then read 1 foundational legal instrument in that your prospective niche area. Remember I mentioned NDPA, I mentioned Arbitration and Mediation Act, I mentioned Investment and Securities Act. These are just some of the laws. There are so many others. So when you identify, then you read the foundational instrument, you read the regulations, you read the guidelines, right? You read the rules under that particular legislation. Then identify at least 2 mentor, sponsor, or a pair, and then send a substantial message to them. So we're here in conference, we're networking. Don't allow your networking just to be at surface level. After you collect the contact details or the LinkedIn details of somebody, send them a message. Dear Mr. So, I met you at the MBA conference when you spoke about fees, and it really resonated with me. I had this issue. Just write an email or a message so that the person can respond to you. Then be available to assist. If you find out that your mentor is very involved in a particular area of law that you are also interested in, you can even ask to write, to co-author articles together. 3 substantive pieces of analysis in that your chosen niche. Your publication could be on your LinkedIn. Your publication, you could send it to a particular body for publication. Just write some deep analysis on that particular area. Then you can join a relevant professional body. Remember that it's not just in Nigeria. Abroad, paper matters a lot. Your certification matters a lot. So, yes, you can read the area, but it's always good to have some professional body backing you up to say, yes, you have been certified in this area. Then think about, as I said, taking up a visible institutional or pro bono project. Remember I said, talking to your mentor, you find out that, your mentor is involved in a particular project, your mentor is involved in a particular charity. Speak to them that I want to serve, I want to volunteer. That's where you are getting exposure, right? So these are some of the things we can do in the next 6 months. Then within the next 12 months, after we have done all this, try to seek out either a speaking position, publishing opportunity, or it could even be being a ESCO member, a committee member in a particular section of the MBA or any other professional body, seek that out. Then develop one signature work product and demonstrate your expertise concretely. Remember, we talked about writing some short pieces, your substantial analysis. Now you can do a detailed job that can go into a proper professional journal. Then finally, formalize at least one of the tasks. I have to look prospectively into the future. In the next 5 years, in the next 10 years, will this still be relevant? If I can answer that question and say myself yes, then I can continue investing in that area of law. So I hope that with these few minutes, I've been able to set the stage, and I leave it to my rest of my panelists to take it up from there. Thank you so much.
Thank you very much. For the sake of such a wonderful presentation, can we give her another round of applause, please? Thank you so much. Thank you. When she was speaking, I was struggling between, thank you. When she was speaking, I was struggling between her voice and the message being passed. Thank God I was able to conquer that. So a lot of young lawyers want to be mentored, but sometimes they struggle to bring something to the table as well. So that's a good nudge for us, and we thank you for that insight. We are going to move forward straight into the panel session. My brother Ikechukwu has been waiting. So at this point, I'll move the mic to Ikechukwu.
All right, good afternoon once more, everyone. Good afternoon. All right, we'll go very straight to the panel session. Thank you very much, Madam Daffy, for your opening. It was very enlightening. Firstly, let me just start this way, just an opening. The Nigerian Bar Association has about 144,000 lawyers across 129 branches. Now, the Nigerian Law School produces for every cycle circa 5,000 lawyers being put into the legal space. Now, if you do the calculation, you know that on an average, we'll be maxing maybe between now and 2027, we should have about 160,000 lawyers. So my first question would be to the person closest to me, Mr. Adam. Okay, so the first question would be, as a lawyer that is entering into the space, what should a new wig first prioritize in the first 5 years of his practice?
Hello. Okay. All right. Thank you very much. Please, can we confirm that we can hear me?
Yeah.
Okay. The question is, as a young lawyer that is entering the market, what should be your priority in the first 5 years or 5 years of your practice? And my simple answer to that would be build a reputation around competence and substance and not noise. I will take it again. As a young lawyer that is entering the practice as a new wig, build a reputation around competence and substance and not noise. What we notice among young lawyers these days is that everybody just wants to be popular. Everybody just wants to be known around the country. But what are you known for? There is a conversation around compulsory pupillage. I mean, I started my own firm in 2023 after working for a total of 9 years. And my default position is this. There is no how you want to do it. You must do pupillage as a lawyer. I don't believe that once you finish law school, with due respect to those that have done it, once you finish law school, you can open a law firm and start practicing. No. You must do pupillage, whether for 2 years, whether for 5 years, or whatever. Because the pupillage you are doing, I mean, there is a conversation about welfare, which would
probably talk about much later. But the essence of that pupillage is that you are building competence. You are building substance. Trust me, whatever you are taught in the university for 5 years and law school are never enough to sustain yourself in the knowledge of the trade of knowledge that we are practicing. So you must attach yourself to a law firm that offers competence. A law firm where even when you leave that law firm, you know, they don't want to let you go. And substance. Your knowledge of law has to be on point. When people remember you, when an issue happens, either on social media or in an office or in a space, you should come to mind such that your contribution to that particular issue is coming from a place of knowledge. It's not coming from a place of bias or emotions. And that's how you build substance. Educate yourself and re-educate yourself. These days, LLB, BL, they are never enough. Go for masters, go for certifications. Arbitration is there. So many areas of law are emerging. And that's how you build competence. Because trust me, a client that comes back to you trusts your knowledge. A client that does not come back, sometimes it's not even because of money, it's because they didn't get the substance that they expected from you. So please, in the first 5 years of your life as a lawyer, build competence around, build a reputation around competence and substance, and not noise. Noise in the sense that, to be very honest, it is easy to make an argument on a particular issue of law. But is that particular issue of law founded in an established position of law? Is it supported by case law? Is it supported by recent legislation? Because if you make an argument that is only an emotive argument, there's no way a client will trust your judgment. If you advise a client, like the first speaker said, a client is not interested in copious provisions of the law. They need you to look at the particular problems they have and solve it. And you cannot solve a client's problem without substance. You have to solve it with specific accuracy. And that's the job of a lawyer. Because there's always a saying that AI is coming to take everybody's job. It's only a lawyer that does not have substance. It's only a lawyer that is incompetent that AI will take their job. So I will land it on a final note by saying, when you are building competence, understand that your strength is your knowledge. When you are building substance, understand that your strength is your knowledge. Thank you.
There is the concept of a complete professional. So one is to have the technical experience, and that is very good, and that is the most important thing. In fact, where the technical experience is missing, every other thing you are about, whether commercial awareness, reliability, accuracy, they are all packaging. And packaging, as you know, is have a short lifespan. Eventually, you'll be found out as an incompetent person. So first should be competence. Technical competence is very key. But another thing is to understand the business of law. And just like I will appreciate the first speaker when she mentioned about you having a broad knowledge of things. So that's what I will call a T theory. You know, like letter T, it's like this and straight like this. So you have a broad knowledge of things. And then later, you can now specialize. And that is how it works. So I personally, except you are cut out for it, I will not say you should specialize immediately. Just have a broad knowledge. And so that if you are to supervise something later in the future, you have at least a working understanding of what it is. So the T theory always, first draw the line across. That is your broader interest. Then you narrow down. That is the T theory. So technical knowledge is not enough. You must understand the business of law. And for you to understand the business of law, you must be commercially aware, you must be smart, and you must take timing as a very important factor in the legal profession. Because I will tell you something, AI and technology has disrupted our practice a bit. And I'll tell you why. Because the first level draft cannot be produced by anyone, including your clients. So now it is whether, how can you now make the law work? AI might not tell you that, but AI can help you analyze. And that is the first job of a lawyer. So now you have to do beyond that. So now say, okay, this point that AI has even flagged, is it even important? And that is where your technical knowledge comes in. So it's very important to make that distinction.
Thank you very much, sir. Okay, so now our next question. So a commentary in 2022 done by the MBA, the MBA committee, spoke to the fact that about out of 33% of lawyers that were surveyed, about half of them, about 50% of the 33%, were not earning up to 70,000. And at the time, which was in 2022, the living expenses was between the amount of 84,000 naira to 144,000 naira. So now my question would be to Mr. Farouk. What skills must a lawyer quickly learn to be able to push up his earning capacity?
Thank you very much for the question. The starting point for me is that I believe it is very possible to have a regulated compensation market in the legal profession. In other words, I do not think it is correct, as we might have seen over the past few years, that it is not possible to have minimum wage for lawyers. So, I mean, it's very easy to dissect. The first is that as of today, the minimum wage is about 70,000 naira. That, I believe, is for someone who is either unskilled or even has no form of certification at all. In other words, you don't even need to have up to a school certificate for you to earn up to 70,000 naira. Now, for someone who has just finished university or any institution and has been enrolled for the National Youth Service Scheme, the government, I believe, pays youth corps members about 77,000. So when you consider what it takes to become a lawyer in Nigeria or in any part of the world at all, I believe it is absolutely unacceptable that a lawyer should earn anything less than 150 to 200,000 naira. It is absolutely unacceptable. And it is possible for the MBA or the General Counsel of the Bar or the body of benchers to have legislation or regulation in place to ensure that lawyers are properly remunerated. It is possible. And rest assured, it matters not whether you practice in Ekiti State or Sokoto or Abuja or Lagos. The minimum wage across the country remains the same. So if you look at it from that angle, the employers of lawyers in the profession owe young lawyers a primary responsibility to ensure that they are well remunerated. If, as a principal that owns a law firm, you contend that you're unable to pay your lawyers up to 200,000 naira because of the environment you practice in, then you probably have no business practicing law. Better still, maybe you have no business running a law firm. So I think for a start, our principals, law firm owners, and administrators must appreciate the need to compensate lawyers properly. It is unacceptable for someone who has not undergone any form of education at all to be eligible to earn up to 70,000 naira. And then a lawyer who has spent 5 years in the university, who has gone to law school, will be earning anything less than 200 to 50,000 naira. That is my foundational response. Now, speaking of skills that a lawyer would need to obtain to ensure that his earning capacity or power is properly maintained, I think for me, the foundation for anyone who has been called to the bar is to ensure that excellence remains his watchword. Excellence can never be compromised. Competence and excellence are the starting point for any lawyer. At no point should a young lawyer become so complacent that he or she believes that there is no room for him to learn or grow. So the starting point is ensure that you are excellent. Once you're excellent, rest assured, there is no principal that can keep you in his or her firm and keep paying you peanuts without you having any alternative. The second is that once you're excellent, if your principal continues to treat you the way he or she believes is fair, even though it does not match the market realities, then, you are at liberty to take work on your own. It's either you're taking work on your own or even people that come to that firm to brief the firm to work, start observing that this person is actually excellent, the person is competent, and maybe I should meet this person. And I think once you've been able to build the foundation by ensuring that independent of whatever the compensation system is where you're working, once you're able to say to yourself that I'm doing well for myself as a lawyer in terms of my knowledge acquisition, my striving for excellence, then I think the ball then is in your court to decide on whether you want to negotiate a better compensation with your principal, or you want to branch out, or you want to move to another firm. So that's my position. Thank you.
Just starting from where you stopped with respect to going to another firm, yeah. I'm going to ask Onye a question. Now, my question is, when should a junior lawyer decide to stay, negotiate, or move? I know it's an interesting question, but so please list it. Thank you.
Question. And to be fair, I think it's subjective, depending on where you're working. For instance, there are lots of firms that are very, it's a good place. Let me put it this way. So it's a good place to grow and develop yourself. They invest in young lawyers. So it depends on why you want to leave. For us, the Gen Zs, right, we take mental health seriously. So if it gets to a point where it's affecting your mental health, for whatever that means for you, I think you should leave. But if it's just about the pay, right, but they invest in other things, you have law firms that invest in young lawyers. They send you to gatherings like this, so the MBA conference, they send you to SBA. They even encourage you to travel and go for certification courses. And when I say this, I don't take it lightly, because where I work, they support young lawyers, and I will never encourage anybody to just up and leave just because, they heard in a certain firm they are paying more. Because personally, and I think it should be that way for a lot of us young lawyers, it shouldn't be about the money at the very beginning, right? Once you have a good pay, a standard pay, whatever that means for you again, I think it's okay to stay and grow before you leave and not just up and go, right? So that will be my response. Yeah.
All right, thank you. The next question, please. I implore my panelists to just keep it under like 1 hour, 1 minute, 30 seconds, so we could just run. Thank you. So the next question with respect to mental health. You talk about mental health. If we don't speak about mental health, I know many people will meet me outside and they will deal with me, so I have to speak about it. So, to Mr. Dim, my question is, how can you
developing myself in a way that I can attend to the issues of client, not putting my burden on another person. Most issues that young lawyers suffer is because rather than taking responsibilities for their law practice, they've transferred the burden of their survival to a principal. And for those of us who now run our firms, we also know the burden it is to run the firm and survive the lawyers in the firm. So more importantly is to have lawyers in a firm who are capable enough to ensure that the results that the clients need are provided for them. That way, a firm can function adequately. So if we run into feeling like our mental health is affected, your mental health shouldn't be affected if there's a tax at hand. For example, we have law firms where a principal is in the office, okay? Working, I stay in my office sometimes, I could be working till 10, 11. But I would have the younger colleagues, 1, 2, 3, 4, 5 years post-call, leave the office at about the closing time, except I put them on that space. Now, I'm not in the office because I just want to sit there. I'm in the office because I have overburdening tasks to deal with. So where there are such tasks, am I going to complain to my client that, please, my mental health is affected, so please, I can't do your job? No. So if you are serving as a young lawyer in a law firm, you are giving into the competence of that law firm so that the clients can find trust in the law firm. So yes, it's okay to have reasonable conversations with whoever is leading you to know when you are breaking out. And that is why lawyers are very happy in the conference, because we feel this is our time to relax. But more than that, taking out so much of mental worries, you now look at, I'm on a journey, I'm in self-development. If I'm serving in a firm, I'm only there for the main time to build myself and give value to that firm until I'm full enough to start up my practice. And the moment you build through and you are energized enough, you, like we would say sometimes, wounded enough to start your practice, by the time you start, you won't break out. Because if you feel you are emotionally worried and you start your practice and you feel pressure from clients, you might leave the practice, and while you are working, you say you want to work somewhere else. So we need to build that mental stamina as lawyers. It is out of that mental stamina that our clients can find trust in us to be able to relate all their worries to us and be sure that we will give that reasonable solution that they require. Thank you so much.
Okay, I'll come back to you. That will be the last question we'll answer on this panel. But I'll go to Madam Daffy for now. With respect to mentorship, right? What do you think makes a senior lawyer invest in a junior lawyer?
Well, can you hear me? Yeah. I think that's a really interesting question as to what you see in someone to invest in them. And I want to give an example. I don't know if it's here. There's a junior colleague of mine. His name is Tosin. When Tosin was in university, my law firm, we do something we call Catch Them Young, where we go to law faculties to organize moot competition. Now, Tosin found out about this competition and emailed me directly and said, "Madam, please, I would like you to do Catch Them Young program in my university." And I told him that there was no budget because we had expended our budget for that year, that he should message me again in January. Without fail, Tosin messaged me in January that, "Madam, it is now a new year. You told me to contact you, and I am contacting you again." And we kept our promise. We ensured we did Catch Them Young at Osun State University that year. Now, even when he was going to law school, he informed me he was going to law school. When he needed a place to do his PPA, he also informed me. And we have that, he's a lawyer now, and that relationship has continued. There's no way he calls me now to do a program, to come on a webinar. It's very hard for me to say no. What am I saying? Be respectful and be persistent. Don't just because I said no, there's no budget. I gave you a leeway. You can come the next year. So if someone gives a pushback, it's not for you to just run away and say, that senior lawyer is very harsh. No, come again. And honestly, I'm always so impressed with lawyers that come up to me and say, "Oh, I met you at this conference, I did this," or, as I said, create value. When you create value, give value to somebody, they will also want to give value to you. So I think that's just the thing. Be consistent. When you are consistent, when you are persistent, it's very, very difficult for people to say no.
Thank you so much, Ma. That was very spot on. So just coming back to the mental health question, we're going to end on this because it's something that I know there is a conversation that is going on in our present day practice. Now, how do you create the balance, right? You resume work ordinarily 9 a.m., right? And depending on the law from where you work, you can close 4 p.m. officially or 5 p.m. officially. Now, there are times where work shoots out from the usual timeline. There are times where you're called on holidays to do one or two things. How are you able to create that balance? Now, this question is going to be for everybody. Everybody will just chime in, and then we'll close on this. Thank you. I'll start with you.
All right. Thank you. How to strike a balance? Well, for anyone who knows me, they know that when it comes to legal practice, I'm very active. When it comes to social events, I am very active. And when it comes to family affairs, I don't compromise it. So it boils down to your ability or developing ability to multitask. Trust me, if you say, oh, you want to practice law, you want to be diligent and all of that, you will not have any private or social life. I worked with Solaniwa Ajayi before I started my firm. And working with Solaniwa Ajayi, it means they owe you 24/7. And you can't blame them because, if you look at some of these big firms, for tier 1 law firm, tier 2 law firm, or any tier law firm, you realize that what makes them tier 1 law firms is the volume of work they do. Now, if you work in some of these places, if you are not able to multitask, your mental health will be jeopardized. If you tell a young lawyer that, that's why I was shaking my head. When my learned brother, my learned friend on that side said, the principal is in the office 10 p.m. and the young lawyer is leaving the office by 5 p.m. Of course they should, if they have nothing to do. I know some law firms where they can't go home if their principal is still in the office. I'm like, why? There's nothing to do. And for days that you know that you have to work beyond, in my own office, we work 9 to 5. We go to the office on Mondays, Wednesdays, and Fridays. We don't go to office on Tuesdays and Thursdays. We work from home. So as a principal, if you need to manage your staff mental health, you have to be able to create some flexibility for them. Number 2, you need to make working beyond closing time attractive. In my firm at some point, we just do hangouts, we do, TGIF, we do just to make it interesting for them. Because the truth of the matter is that even a slave, if you don't work beyond the closing time, because I will see you as a lazy lawyer if there is job to do and you are carrying your bag to go home. But I will see you as an oppressive principal if there is no job to do and you are expecting your lawyer to stay in the office. It does not make any sense to me. Pardon my choice of words. Thank you.
It appears that Mr. Adam has spoken the mind of a majority here. Well,
1 second. I want to share. No, just so we balance the scenario, I would want to highlight some points. Now, I run 2 law offices, 2 branches of my law office, one in Bayelsa, one in Lagos. Part of the things I'm doing is to ensure that we also engage specialization by lawyers, such that some are attending to specific areas of law practice. Another benefit my juniors have in my office, which is the reason why I think it is necessary sometimes for them to develop themselves and their capacities, is because the juniors in my firm benefit and share professional fees. So where professional fees come into the firm of about 10 million naira, and 3 lawyers are engaged to do that brief, and they all benefit from the professional fee. It means that at every time there is a task, they are all supposed to be involved in the task. So it doesn't necessarily mean that young lawyers should sit in a firm when they are not doing anything, and then because their principal is there, they have to be there. I understand that sometimes for some firms, the remuneration might not be so much, so they feel, no, we should be let to go. But all I'm saying in the midst of this, as much as all the principals might not be alike, the essence of growth in a law firm is to build strength. Just like he said, a first-tier law firm has a lot of tasks. So if you have the task at hand and you are able to build yourself to be available to do the task, and you can also benefit from the resources that can come from those tasks, then it is necessary for the lawyer to engage accordingly for excellence in the legal profession.
All right, thank you so much. Thank you so much. So with this, unfortunately, we wanted to just go ahead, but we have other activities that we need to carry out within this panel session. So it's indeed a honor and a privilege to have everyone here join this panel session. We hope that you are able to glean one or two things to be able to help you to build a career that you can be able to build, thrive, and also be able to know how to position yourself within the market. So thank you very much, and do have a lovely rest of the evening.
No question. No question.
Thank you so much, Mr. Ikechukwu. Please help me put another round of applause for this panel. Very rich, really very rich. And, these gatherings do not afford us enough time to get deep. So what you can do after now is their names are all here. You can follow them, look them up on the internet and social media and get to hear more. And we also hold more webinar sessions. We're really constrained with time, but we appreciate your presence and the knowledge you've just shared with us. And we also have something for you, but we'll do that in a minute. We want to take one item and then call you back. So please, maybe we just have, we'll come back to have a group photograph and also a presentation. Right, so please, thank you very much, and please, we appreciate you. We'll come back we'll call you back very shortly. Very shortly. Please bear with us. We are young lawyers. We don't know it all. We are learning how to coordinate things. So, oh, okay. See, I just told you. We're learning the ropes. So please, we still want to have your company here. So you join us. Yeah, off stage. All right, so we have a couple of other items, but I want to welcome Mr. Goswell Alako to take the next one. Thank you.
Please, a round of applause for this session. Please, you can do better. A round of applause for our distinguished panelists. My name is Goswell Alako, and we're going straight into the next session in this program for today. I'll stand on the existing protocol as we are right behind time. I'll go ahead to call on, I would want to say the MBA YLF, this particular executive, as we know, we're coming to an end, but they have decided to start up something that is going to be here even beyond them. So we have the launching of our journal and the magazine today. So without further ado, I would like to call on the chairman of that editorial committee, as well as the chairperson of the continuing legal education, the chairman of the editorial committee in the person of Jamiu Isiaka, and the chairperson of the MBA YLF continuing legal education in the person of Miss Omotayo Mary Dada, who is here ably represented by Miss Karina Esquire. Please put your hands together for them.
Thank you very much.
Mr. President, the NBA YLF editorial board has done nothing spectacular other than keying into your vision. And I could remember that on several fora, you kept reiterating the rationale behind the formation of the Young Lawyers Forum, which are to promote professional growth, welfare, inclusivity, among other things. Mr. President, we are glad that we have been able to put a face to that vision today by producing the maiden edition of the Nigerian Bar Association Young Lawyers Forum Journal, titled Lex et Populi, the Law and the People. Mr. President, this journal is published in honor of a legal giant, a man who has touched the life of young lawyers. As a lecturer at the Nigerian Law School, each time I assess students upon arrival from their externship, those who did their externship in the office of the man in which we published this journal in his honor, the commendation is worth it. He is a man that has contributed so much in his private aspect into the legal profession. It is my singular honor to inform Mr. President and the entire Young Lawyers Forum that the Lex et Populi journal is published in honor of J.J. Usman, SAN. Thank you, Mr. President.
Good afternoon, everybody. Mr. President, distinguished senior advocates of Nigeria, learned colleagues and friends, learned seniors, of course. My name is Karinate Olali. I'm a lawyer and an international trade professional. I work within the ECOWAS region, and I have the privilege of speaking on behalf of the chairperson of the Committee on Legal Education, Continuing Legal Education, for the unveiling of our publication, No Straight Line, 100 Lawyers, 100 Different Journeys. The publication is at its heart the versatility of a lawyer. We want to celebrate that. We often speak about the legal profession as though it's a prescribed path, law school, practice, partnership, the bench, but these pages tell a different story. They show us lawyers in litigation, on the bench, in corporate, in academia, public service, business, development, policy, entertainment, the whole works. We have captured the journeys of 96 lawyers across generations and professions, including remarkable stories such as those of the NBA president, Aigemo Kwede, and our very own OCJ Okocha, and many others whose paths demonstrate that there is truly no straight line. Our hope is that a young lawyer reading this publication will discover not only careers they have never considered, but also the courage to pursue a path that they may not have a name for. A law degree is a foundation and not a cage. The possibilities are as broad as you know, and it's our hope that as you read this, you get all of the information that you need, and it guides you for young lawyers and, of course, lawyers that have been called to the bar, and that you see many possibilities that abound. Thank you very much.
Please, a better round of applause. We'll call on our chairman of the editorial committee, in the person of Jamiu Siaka, once more, to formally introduce this work. Put your hands together for him.
Thank you once more. At this juncture, may I respectfully invite to the podium our father, our leader, the man whose vision we are riding on. Please, let's appreciate the president of the Nigerian Bar Association, Mazi Afam Osigwe, SAN. Yes, sir. So please, with other special
dignitaries here present for the unveiling of the Nigerian Bar Association Young Lawyers Forum, Lex Ex Populi, the law and the people. Mr. President, you are highly welcome. We also call on the President-elect, Mrs. Oyinkansola Badejo Okunsanya, Senior Advocate of Nigeria. Please, let's also welcome the chairman, the man who made it possible for us to be here. He needs no introduction. Please, let's welcome Mr. Abdul S.A.N., Senior Advocate of Nigeria, and our leader from the Kanu Bar, Mr. Gadaya, Senior Advocate of Nigeria. Yes, at this point, let me invite the legal giant, the man whose name we published this journal in his honor. Please, let's make welcome of J.J. Usman, Senior Advocate of Nigeria. Okay, I have been directed to also call on stage our swagalicious Senator Dino Melaye.
In this journal to please join up upstage for the photograph. Thank you.
So the idea behind this law journal is not just to be a one-off publication, although it's a maiden edition, but the idea is to ensure that the future generation continue from where we have started from. Thank you. And all other senior advocates here present, please, you are invited to the stage. The chairman of the Nigerian Bar Association Young Lawyers Forum, please step up the stage.
Let me greet my big brother.
But we're dealing with it.
Yes.
I was asked to come because of this. One thing before the other. What do I do? Just to engage. How do they say it? What do I do? You are the president of the organization. Well, I think I've been asked to unveil this, even though we can see it. It's not veiled. Maybe it would be nice to give a copy to all the people here on stage, or most of us that you have invited, so that at least you can all raise it and say we have unveiled it. Jamil, can we get more copies? While we are waiting for more copies of the magazine, let me congratulate the NBA Young Lawyers Forum and then also correct an impression. The YLF does not stand on my vision. I met YLF at some point in my practice, and it will be unfair to those like J.B. Daudu and some other NBA presidents who labored to put a structure for it in place to suggest that the YLF stands on my vision. If anything, we may have tried to encourage YLF and key into the vision of the founding fathers, but I'm not the person who originated that vision. And I will not, because we are here, take an attribute that does not belong to me. And so I've been asked to unveil what is not veiled. So on behalf of the NBA YLF, I hereby unveil this not veiled magazine. And to say that nobody will be asked to launch it. But if any of you here feels the compelling need to support the YLF so that it will continue to produce this journal, you may privately discuss that with the YLF leadership. And it has a beautiful picture of my good friend and my lawyer, sometimes my lawyer. If I allow him, he will tell the whole how I don't pay him professional fees. When I saw the magazine, I actually thought it was Lord Denning, but it's not Lord Denning. So to the glory of God and to the advancement of the legal profession and encouragement of scholarship amongst lawyers, we present this magazine and also thank those who worked hard to produce it. To the glory of God, we will unveil it. You will now, There's another magazine I was not asked to unveil that. I think the president-elect should take over from that point.
Thank you very much, Mr. President. At this stage, may we honorably invite our mother, the president-elect, Mrs. Oyinkansola Badejo Okunse.
Learned senior advocates, I've told Mr. President that this excitement that he's demonstrating at the fact that in the next few hours, he will no longer represent, he's scaring me. I don't like his excitement. I don't like his excitement. And you know, many things can happen in Nigeria. So extension of time and other such things. So please, Mr. President, blessing this excitement, lest I develop cold feet. It's a wonderful thing. I love what Mr. President said. This is worthy of encouragement. And this, no straight line, 100 lawyers, spotlight, 100 different journeys. I love this. Because from other people's journeys, we can learn so much. And so, it's my pleasure and my privilege to present this, because it's been unveiled already, to present it to all and commend it to everyone. Please read it. Many of us don't read enough. But we like Amebo, so if we're reading people's journeys, it's not like reading. So if we read it, trust me, we will all learn something from other people's journeys. To the glory of God, humanity, and the advancement of the legal profession, I present this book to you all. Thank you.
Thank you, Madam President-elect. May we quickly call on J.J. Usman, Senior Advocate of Nigeria, to please bless us with his own remark.
Mr. President, Chief Mazi Afam Osigwe, Senior Advocate of Nigeria, live bencher, my leader, and sometimes my clients. Your Excellency, Madam President-elect, and all distinguished colleagues, it's a pleasure for me this afternoon to be honored by the YLF, which I am a prominent member. As a young lawyer, I am a member of YLF. Mr. President, when I was informed that this magazine will be unveiled in my honor, I felt I have not done anything to deserve the honor. But the saying that to whom much is given, much is expected, I think is what has been bestowed upon me this afternoon. Because I know there are many prominent lawyers that have contributed to the development of YLF, but you chose to honor me this way. I sincerely thank you. I sincerely appreciate this honor, and I openly undertake
to be part of YLF any day, anytime, anywhere. Mr. President has placed a ban on donations, and that ruling is an unappealable ruling. Else, I would have passed the microphone to some of my billionaire friends here. Why is Ravindade looking at me? So, Mr. President, you have said it all. For those that have a contribution to the YLF in our private dealings, we will support them. Thank you, YLF. God bless you.
Yes, at this point, Mr. President has done so much. We don't have what to give to him, but the little we have, we want to appreciate our father, who has contributed. He gave us the opportunity to strive. He gave us the platform within which we are using today. We are very grateful, Mr. President. You have G-Wagon already, I know. You have Lamborghini. But this one, you have been given before, but this particular one we are giving to you is coming from us. Please, this is the least we can do. Thank you, Mr. President. Now may we welcome, because I don't have the capacity to present this award of recognition to Mr. President. No locus, bar locus. Let me please welcome the President-elect, Mrs. Badejo Olayinka Okusanya, to please, SAN, to please present this award of recognition to our president. Thank you, ma'am.
Say after me, Badejo Okusanya.
Badejo Okusanya.
Well done.
As Senior Advocate of Nigeria.
Well done. Not SAS. Next time I see you, I'll ask you, and you repeat it exactly like that. Mr. President, your children have come to say thank you in a most profound way. It's a wonderful thing when the things that we do are appreciated. And they've come to present this wonderful portrait to you, which I'm sure will adorn a pride of place in your office or home in appreciation of all the support that you gave them during their tenure that has enabled them to achieve all that they have. And so this award is presented to you in recognition of your outstanding leadership, your support and commitment towards the development of the NBA YLF. We appreciate the opportunity you gave us to serve, to thrive, and break limits. Congratulations, Mr. President, from all of us in the NBA YLF Governing Council 2024 to 2026. Congratulations, Mr. President. I present this to you on their behalf from the very grateful hearts in the NBA YLF. Congratulations, sir.
I will only say thank you all so very much. I'm touched that I could go to this extent, and I will actually cherish and treasure this. Thank you. God bless all of you.
So we'll go straight to the photograph session. The contributors to the journal, as well as the panelists. Thank you so much, Mr. President, and our dear President-elect. Thank you for honoring us today, and we say thank you. Thank you, Mr. President. At this juncture, I would like to invite I'd like to invite the president of the NBA Young Lawyers Forum for his closing remark. Would like to call our learned senior advocate of Nigeria, J.J. Usman. Learned SAN, we have an award for you, as well as our learned senior advocate, Sami Somiari, SAN. We would like to invite you, the learned SAN, Sami Somiari, ably represented here. Please, a round of applause for this MBA executive. They have done a fantabulous and remarkable thing. We would like to, at this moment, also for this award presentation, would like to invite up to the podium the learned SAN, Babatunde Ogala SAN. Please, sir, do us the rare honor of presenting this award to learned SAN. Please put your hands together for the learned SAN as he comes to present this award. Please, a round of applause. A round of applause as he comes up the podium. And would officially invite the learned SAN, J.J. Usman, Senior Advocate of Nigeria, as he comes up to receive this award. Sir, thank you so much. You're welcome, sir. Put your hands together as the learned SAN comes. Yes.
The microphone, speak. You might hold it.
This is from YN.
Yes.
Yes.
Yeah.
Well, I don't know. Well, on behalf of us, the Young Lawyers Forum, I'm one of the young lawyers. A 40-year-old man is a young man, and I'm only 40 years at the bar. So on behalf of us, the young lawyers, we present to you J.J. Usman, Senior Advocate of Nigeria, this award of excellence in recognition of your constant support and encouragement of the Nigerian Bar Association Young Lawyers Forum. And it says, so I was perfectly in order, from us all at the YNF Governing Council 2022-24. We hereby present this to you as our own token. Thank you.
Congratulations, sir. Congratulations, sir. Thank you, learned SAN. Please put your hands together for the learned SANs. Okay, okay. Would invite the second presentation or awardee, still to be presented to by the Leonard SAN. We want to call up the Leonard SAN Sami Somiari, Senior Advocate of Nigeria, here ably represented by Emmanuel Okafo. Please put your hands together.
Again, I'll say to you, let's assume the Sami I know is male, but I know there are also female Samis. So let's assume this is Sami Somiari that is before us. So on behalf of us, in the Young Lawyers Forum, we present to you this Award of Excellence, Sami Somiari SAN, here ably represented, in recognition of your constant support and encouragement to us at the NBA Young Lawyers Forum from all of us in the Governing Council 2024-2026. Thank you very much for your support, and we hereby present.
Thank you very much, sir. We appreciate it. Yes, sir. Thank you, sir. We're very grateful. Thank you so much, Leonard Silk. Thank you. It's been a long day, and we are about the end of it. Let me start by appreciating our panelists for their very humble generosity with time. And we apologize for this. I started by saying that we're young lawyers, we're learning the ropes, so I hope you please bear with us. I promise you, you won't be here in the next 5 minutes. And to make sure of that, I want to welcome the managing partner of Obra Legal, Mr. Ikechukwu Onoma SAN, who will present who will take on the award presentation session for our panelists. Please help me get the awards closed. Please let's welcome Mr. Ikechukwu Onoma SAN. Please let's appreciate him. The managing partner of Obra Legal LP. Thank you so much, sir. Thank you. And we thank you to everyone who has been here till now. We'll be out here in a very few minutes. I would also, to join the photograph, I welcome the chairman of the Young Lawyers Forum, national chairman. Yes, the chairman and other members of the governing council. Please come along so you can join. Okay. All right, so in no particular order, we'll start just in the same way we arrived. Yes, please. Thank you.
Thank you very much. We're going to be very fast and quick. I just want to, on behalf of the Nigerian Bar Association, Young YLF, to thank Imokini for the beautiful rendition and the presentation he made. It was very inspiring. I got the 3 pillars. So here is a gift, a token, and an award to show appreciation. Okay. We need to be close to the camera. Okay. This one here, on behalf of YLF Nigerian Bar Association, we thank you for the beautiful speech and also the panel session. Thank you very much. Thank you very much. Miss Onye is the. Miss Onye, are you tired? Thank you, Ms. Onye, for that beautiful panel session and the contributions. On behalf of YLF Nigerian Bar Association, thank you very much. Abila. I don't want to attempt to pronounce the surname. Okay, that's fine. Abila is actually the surname. Abila is the surname. So the first name is... Then we can go with Abila. Yes, Mr. Abila, thank you very much for the panel session. On behalf of Nigeria Bar Association, YLF, we present this to you, and thank you. Omar Farouk, thank you very much for the beautiful panel presentation. On behalf of Nigerian Bar Association, YLF, we present this. Thank you. Mr. Mohammed, thank you very much. On behalf of Nigerian Bar Association, YLF, thank you. Is it true that your name is Ikechukwu? Oh, no. Thank you very much, Ikechukwu, for moderating this beautiful session and also very, very educative. Thank you.
Thank you so much, Leonard Seal. Please, maybe rise for a group photograph. We'll have a group photograph. All the council members should please join. The chairman of branches. YLF chairman of branches, please. We can go to the other side.
Unless you have to be our father now.
Former YLF chairman, please come around. Thank you very much. We extend our deepest appreciation to our panelists and to you, sir. Thank you so much. Thank you. Thank you. Thank you. Thank you. Thank you so much, everyone. So please look them up, connect with them. Also, while you are seated, look up the next young lawyer close to you, connect with them. We have a couple of announcements. There's a missing phone from this hall, if you've seen any. It's a Redmi A3 phone with a blue cover. Please just bring it on stage here. Just bring it on stage here. A Redmi phone, A3, with a blue cover. We announced earlier that there's a missing purse. We have the purse here. If you misplaced your purse, a female black purse, please come and identify that as well. Then we've also talked about branding. We have a book on branding being sold by one of us. It's at the exhibition center. She's also brought it here. I have a copy here. It goes for 5,000 naira. A very easy to read book. The name is Influencer. So if you're looking to learn about how to brand as a lawyer, you may want to get this book. She's right here, so she can also give you an autograph So you can come meet me if you want this one. Tomorrow, the MBA section on law practice invites us to tomorrow is the MBA section on law practice annual general meeting right here by 9 a.m. They've announced that the first 100 persons will get a gift. If you're here from 8:30 to 9, you get a special gift from the section on law practice. I want to invite Honorable Imo Akpan for the presentation to the chairman. Honorable Imo, to the chairman of committees. Please, let's have him. Honorable Imo Akpan. I thank you. What? Yes, the magazines, it will be distributed later. If you're picking here, it means you are launching it at a very high price for us, and we appreciate that. But the copies here are limited for launching, but it will be distributed much later. Thank you for having me. So, please, we still have a missing purse here. Please come and claim your purse if it is yours. We have a missing phone. Please report here to get. We want to welcome on stage Omotayo Mary Dada, the chairman of the MBA YLF Continuing Legal Education Committee. Please come on stage to receive your award. Represented by Karina Oladipo. She's here. Please come up, make your way to the stage. We also want to call up Etie Ubong Usoro, the chairman of the MBA